And on behalf of Planet Senior Council, Mr. M. J. Samet, I take item number 12. Kindly matter be adjourned for the day.
I think another person is also going to make a. Yes.
May I
Mr.
seek
Nalin.
permission to mention Lordship?
Yes.
Item number 9, Lordship.
Yes.
So I was hoping Lordship would give us a date in September, then I can have the privilege of addressing Lordship in person. If it can be Monday, the 2nd of September, or if you don't do Mondays, then Tuesday, 3rd, whatever is convenient to Lordship.
Hearings are usually on Tuesdays.
Then, as Lordship pleases.
Okay, so we have it on September. When did you say?
3rd, Lordship.
On the press for adjournment made by Mr. Nalin Kohli, and Kohli Learned Senior Counsel, learned counsel for the petition. This is a matter on 3rd. Then in item 12, you have got something to say, I think, also.
Not in 12, Lordship. 9. No, only 9. Today I'm there only for 9, unless I've not been told about 12 so far.
Okay. In 12 is somebody else. Okay.
Thank you, Lordship.
And what about 12? Yes.
Adjourned for the day.
On the 12 for adjournment made on behalf of Mr. MZ
M. J. Samet.
Amit Bennett, Senior Counsel for the petitioner. Petitioners, this is the matter.
Madam, this may be 6th of August.
This is the matter on 6th of August.
Okay, item number 2 and 3. So I'm referring to the department of. Also, in this matter, I have prepared my certificate and for fetching them. So I'm praying for some time so that I can.
Mr. Anybody else there?
I have already informed him. The K. Chaudhary appears.
Mr. P. Nayak, Bennett, Counsel for the PWD, submits that affidavit in opposition has been sent for vetting. Accordingly, praise for.
Let this matter come after 2 weeks. So in the meantime,
This for 2 weeks time. To file the affidavit, this is the matter after 2 weeks.
May it please your lordship, I beg to mention for listing of a matter on 26 lordship. The matter is lordship, in a tender process, my bid was accepted. Thereafter, they have issued a LOA, and in that LOA, they have asked for excessive advanced performance security money lordship against their own notification. So
No, probably, what is your bid amount? How much? Is it less than the estimated amount by how much percentage?
yes, it is less than their
How much? How much percent?
26 point.
That is why. No hurry.
But lordship, they have issued a subsequent communication that within 120, that within 5 days, if I fail to pay that amount.
What is wrong? What is
but
wrong?
It is against their office order, lordship. Office order. So
I doubt.
approach before this honorable court day after tomorrow, lordship. Because the day after tomorrow is the last day. Otherwise, my tender will.
You don't seem to have any case. I'm giving you an advance warning. You please be prepared, because you see, you have made your, probably you have made your tender bid 26% below estimated value.
Yes.
So, I don't think there's anything wrong. I think there's some judgment against.
We are ready to give the performance security money and advanced performance security money. We are also ready to give that, but they have asked for an excessive amount. That is the matter, lordship.
Maybe, but I don't think you.
The excessive amount, lordship.
I don't think you've got a case. Anyway, it's still on Thursday.
This is your lordship. Lordship, I beg to mention item number 8, lordship. Lordship, the matter become infructuous.
Okay, Mr.
I am Hugh Ghosh on behalf of Mr. D.P. Bora, lordship.
What is your name?
Hugh Ghosh.
Huh?
Hugh Ghosh.
Hugh Ghosh, appearing on behalf of Mr. D.P. Bora, Learned Counsel for the petition and submit that the matter has become infructuous. Accordingly, the writ petition is dismissed as infructuous.
Obliged, lordship. Lordship, I would like to mention a matter, writ petition of 2019. I am representing on behalf of Mr. Amit Goel. Lordship, if the matter can be listed next Monday.
What is the matter? But when was it last listed?
It is in regard to restoration of dealership of the petrol pump, and as per order dated 19th December 2019, the matter was supposed to be listed sorry, as per order dated 29 October 2023, the matter was supposed to be listed.
So it has not been listed after that.
Yes, sir.
Okay.
Much of it.
Matthews, Lordship. Lordship, I beg to mention listing of a matter WPC 17125. Lordship, it was listed on 13/12/2023.
When do you want?
2023.
When do you want it to be listed?
May it please your Lordship. I beg to mention for listing one contempt petition not listing since 9/2/2024.
Next week.
May it please your Lordship. I beg to mention for listing of one contempt petition which is not listing since 19th of December 2020.
Item number 20, Lordship, there's an interim order, Lordship, that is to be continued.
Interim order to continue till the next day.
Item from the tender matter regarding the non-payment of contract service.
It's not a tender matter. It's a question of non-payment of contract. It's different thing. When do you want? New matter? Friday.
May I please, your Lordship, I would like to mention item number 10 and 11 of daily list.
10 and 11, yes.
Kindly matter may be passed over for the day. My senior is not one.
Where is your senior?
I am appearing behalf of D. Hussain.
Huh?
D. Hussain.
Where is he?
Sir,
He's in which court? Court number 1? Court number 2? Which court?
sir, he 10 comes.
Huh?
My Lordship, she 10 come to court. High blood pressure.
This is a bad case for you. That's why he can't come probably, huh? Is it? Right. Adjournment application has been made. Adjournment prayer has been made on behalf of Mr. D. Hussain, learned counsel for the petition. Accordingly, list this matter day after tomorrow. Day after tomorrow you come.
Wait, with your Lordship. Present matter is a dispute regarding allotment of rice and its transportation by the GPS, there's a Gaon Panchayat level Samabhai Samiti. Now, what has happened? I'll just give a basic outline of what has happened also. The present society is a British society. They are supposed to lift an allotted quantity of rice, which is allotted by the Food and Civil Supplies Department
From?
from the FCI godowns to their godown and from there to the fair price shops. So that is otherwise the mode of PDS distribution. That is
Why should your society lift it? Is it on the basis of some tender or why? Or on the
this is
basis of some order that has been issued without any selection process?
no. What has happened, the process or the modality that is followed in the state of Assam, which will be admitted by the other side also, is that the government, through the Food and Civil Supplies Department, allots a particular earmarked quantity of rice to the GPSs, which is the Gaon Panchayat level Samabhai Samiti. Now, there is a government scheme.
But how Gaon Panchayat level,
Yes.
this committee, there'll be a lot of committees.
Every
How does he choose the committee? As it
no, Lordship, I'm coming to that. There is a long history behind that. I note. There's a long history behind that. Now, these societies, they were otherwise very much fragmented at one point of time. Thereafter, the government took a decision that for one panchayat, there will be one Samabhai Samiti, one cooperative. Therefore, the name is, nomenclature itself says, Gaon Panchayat level Samabhai Samiti. So one panchayat, one Samabhai. Now, that particular society is otherwise entitled to lift the rice meant for the public or
for that
consumer
panchayat.
of that panchayat. Now, this allotment is given by the Food and Civil Supplies Department, and that is the modality followed, which has also been followed in this case. There is no dispute to that. Under the
NFSA norm, food security. Earlier the PDS system, now the National Food Security Act. These societies are like the middlemen basically. From the FCI godown, they will bring it to their godowns, and from there
They're basically the carrying contractors.
they would be the handling contractor as well as the carrier. Now there is a bit of a bifurcation to that also. The government has now started with a scheme whereby new contractors have been appointed only for the purpose of transportation
From the FCI
from the FCI
to the
to the GPSs
FPS.
to the
Fair price shop.
yes. There is another mode that is the newest mode now. They are saying directly to the fair price shop
So,
dealer.
so bypassing you.
bypassing. That is one step. That is some cases are going on also, but this is not that case. Now here what has happened is in this particular society, we have been lifting that right. There has been no contractor appointed as on date. So that is not the issue here. Now, pursuant to that particular norm, we were lifting. The allotment orders are here, I'll show that also. Now, there was a point of time in 2020 when the society's secretary wrote to the authorities saying that we are financially incapable of lifting the entire lot, what has been allotted to us by the Food and Civil Supplies Department. So therefore, please give us some relief. Accordingly,
Please give us some relief.
insofar as the transportation of the entire quantity is concerned. So accordingly, what has happened as a temporary mode at that point of time, 3 fair price shop dealers were given the responsibility of lifting a particular amount of the entire allotment given to us by them directly. Now that process continued for around 3-4 years. Pursuant to that, the board, there is a board of the society. By elections, they are always changed. So a new board came. Now the new secretary therein now wrote to the authorities saying that presently our economical condition is better. So we would like to now lift the entire allotment that is given to us.
So when did you write the letter?
That was in 2023.
When?
Now,
When 2023?
I'll come to that logic, but this is not the exact situation
Okay.
now I'm standing at. I'm just giving the background, what led to the present situation. Now, pursuant to that letter, there were certain series of communications, interdepartmental communications written by the various authorities saying that yes,
Okay, one thing. So those three fair price shop dealers were also allowed to transport the goods.
yes,
And you were also in the meantime carrying on with the transportation
Yes,
of a
Lord.
portion of the goods.
yes, Lord. Now, because suppose it was like 100%, we were lifting 80%, they were lifting another 20%. Now, pursuant to that, interdepartmental communications, finally a decision was taken that since the society is now ready and willing to lift the entire quantity, let them lift the entire quantity. So orders were passed, thereby cancelling the temporary arrangement with those 3 fair price shop dealers, saying that from now onward, 100% allotment to the present petitioner society and they will give. Now that came to be challenged before this honorable court by these 3 fair price shop dealers, saying that we had a internal agreement with the society based on which we were lifting and we were also paying some commission to the society. And now since that agreement was there, so therefore, how could the department would have cancelled this? The department advocate was there.
Agreement dated
Yes. Agreements were dated 18th of October 2023.
and this agreement was for how long?
It was for 1 year, and this was between the parties only. The government was not involved there. This was the internal arrangement between them. So they came up before this court saying that an agreement was there. The government said, this is an agreement between you. We are not bound by that agreement. Whatever it may be, this is an internal agreement. But this honorable court refused to interfere because they were challenging this order of 100% allotment to us. The honorable court refused to interfere. The honorable court said, no, it doesn't give you an indefeasible right. Be that as it may, the matter was disposed of. However, representation was to be disposed. An order was passed.
Whose
disposal-
representation?
Process
Whose representation was to be
of the
disposed?
fair price shop dealer.
Okay.
Because we were appearing as a respondent. We were a beneficiary. We were now lifting the 100%. Our argument was our allotment. So we are lifting it. There is no harm in that. There was an arrangement at one point of time. Be that as it may, it was a temporary arrangement. Now we are lifting because it was our
No,
attack.
no, but in the agreement that you had made.
Yes.
What was the period during which the fair price shop dealers could or should transport the goods?
That was for 1 year.
1 year.
Yes.
So 1 year will end according to your agreement in October 24.
Yes. So that agreement was not over. But our argument was that was an internal agreement between us that in the event or because of the situation that you are lifting now, so there will be some commission coming to us. This agreement is in fact not to be brought before a court of writ court. This was something that would have been a breach of contract and they would have gone for a civil remedies for that. Be that as it may, the honorable court said a representation, let them file a representation that will be considered. However, this court refused to interfere and the matter was disposed of. Now the matter went back to the authorities. They filed a representation. Now the authorities passed two orders. The first order was saying that both the parties were asked to compromise. They failed to compromise. So therefore now, as if sort of a punishment, let the allotted quantity of the petition society be lifted by another society, a new society. Now he is a totally stranger to this entire proceeding. Simply a windfall profit for the society otherwise. So let them be lifted by another society. And subsequently, that order of the highest authority was complied with by the competent authority at our level by saying an order is passed. Thereby, another society called Uttar Morongi, that is a different society, is allotted, is given the orders for lifting the allotment. So my grievance herein is number one, this particular third party was never in the seat. He doesn't have any right. The rights belongs to us. If at all the authorities could have taken a decision vis-a-vis those this fair price shop dealers and us, there was no rhyme or reason. There is no reasonings given in the order saying why I have to be deprived and they have to be given the benefit who is not even in the scene. They have never filed any application to that regard that they were entitled. So that is the crux of the case. So if I may just show the documents, Lordship.
No, there's one issue here. It goes back again to the main issue.
Yes.
The main thing is, what right does a panchayat, the committee of a particular panchayat, have a right to lift the food grain on behalf of the fair price shop of that panchayat?
If your Lordship will kindly see the allotment order at page 29. This is
No, allotment order is something. Where's the policy decision that a particular committee of a particular panchayat will take care of that panchayat only, and it cannot leave food grains for other panchayats.
that policy document I do not have, but then this is the admitted position prevalent in the state of Assam, will not be objected by the respondent also.
I don't know. It's something that has been going on,
Yes.
but doesn't there is
But
no
because-
bar
because
for
I-
there is no bar for a committee of another panchayat to lift food grains there.
I understand.
Yeah.
This issue didn't. But because it's a admitted position, we have been always doing cases where it is all admitted position. So
Admitted position
it-
does
it
not
is
bar
like
the
my
other.
mind. I apologize for that, Lordship. But then the fact remains that there is no dispute that once an allotment is given to society, it is for that panchayat level, that GPSS. Therefore, it is known as a Gaon Panchayat level Samabhay Samiti.
Maybe, but then where is that issue? That is the crux of the issue.
If this allotment order, if your Lordship will see that the allotment is given vis-a-vis the fair price shops, the entire quota is given here. If I just show those two documents,
But then when was this? Show me page.
the allotment order,
Yes, yes.
page 29. Page 29,
Yes.
your Lordship will see that heading at the top, allocation of commodity, sub-wholesaler wise, FPS is fair price shops wise detail. Now therein, if your Lordship will come to page 31. Page 31 is the petitioner society. Page 31 in the middle,
Where?
wholesaler name, Dokhin Bizni SS Limited. Now, this contains the entire allotment vis-a-vis the fair price shop dealers also, which is totally numbering 142. That your Lordship will see at page 37, Lordship. This list continues till page 37. And from left hand side,
From 44 to 187.
from 44 to 185, Lordship will see the second column. The second
Yes,
column,
yes.
it starts at 1,
Yeah.
ends at 142.
So there is 142 for fair price shop.
So I have total 142 share price shops allotment under my belt. So this is the allotment.
But this is for how long? What is the period? Is this for till kingdom come or what?
This will continue till a new contractor is not appointed, which is reflected in the order itself. If I show the order, Lordship will find out.
Sure.
So first I have shown the allotment. Now
You have shown the allotment, but you have not shown the period of the allotment. There is nothing to show
periods are monthly wise, Lordship.
monthly wise.
Monthly wise.
So this is for which month?
So the month is also, this is computer generated, the month is not there. But then this is monthly.
Okay,
wise.
if it's monthly wise, then this was issued when?
During that relevant time,
That is in 2020.
I will show the latest allotment where 100% was given to you. So Lordship will just bear with me, I'll just show the paper. This was just to indicate that the number of fair price shops that we have under our belt. This document.
No,
That
no,
140.
that is okay.
Yes.
What I want to know is, you have been allotted some fair price shop for which you are supposed to do the carrying of the food grain. Now, this carrying of the food grain on your part is for how long a period? Where is that?
If a Lordship will come to the impugn order, page 72. It's written there, Lord, page 70.
Yeah.
Page 72 is the impugn order.
Hmm.
The last paragraph, your Lordship will see.
Hmm.
As no decision has been received from their end within the stipulated time, hence the Government of Assam and Food, Public Distribution and Consumer Affairs Department has decided till completion of tendering for selection of L1 contractor for lifting of the NFSA rice and distribution of the doorstep to the FP shops of the concerned area of Baksa district, the District Commissioner Baksa may entrust the nearest DPSs of the concerned area to lift the allotted quota of NFSA rice and distribute among the fair price shops of the concerned area. So the outer limit otherwise would be till a new contractor is not appointed, and otherwise the practice is every month allotment orders are issued, which your Lordship will find.
So your right to lift food grains arises month to month.
Month to month.
Then where is the case?
Month to month is the modality that is followed.
Month to
Because
month.
every month I have
But
to
but then where is the basis for you to say that I should continue to be the carrying
For that-
contractor?
For that, then if your Lordship will see the order that was passed in my favor.
No, you see, at the end of the day, the very purpose or the very issue as to why a particular panchayat is the lifting contractor or the carrying contractor has to be shown by you or by them.
Lordship is going to the root of the issue.
I have to
because-
go, I have
yes.
to go to understand the
I-
issue.
yes.
Because that is the very issue that is.
Today I will be incompetent because I didn't carry the policy. But then because I was under the impression, because since it is an admitted position and a prevalent
Admitted,
practice in Assam,
maybe admitted, but then the problem is that I don't know the admitted
I
position.
understand.
And I do not know what is the basis for you saying that it is an admitted position. Well, I've got to,
It actually my fault.
because at the end of the day, the issue that has to be decided is whether the panchayat of the committee of a neighboring panchayat can be the carrying contractor for a panchayat which is outside their jurisdiction.
Yes, but
So that is the
under-
issue.
Under what right? Today the question would be,
No, before
Apart
that,
from-
before that, you have got to show your right. You cannot question other people's right without saying that your right has been violated. Show me your right.
my right has been violated by, I just showed two documents to that effect. Because there are orders in my favor, which seems to have been violated now without.
Which
giving any
seems
reason.
to have, see, we cannot go by which seems to have.
No.
You have got to
That is
show.
for your Lordship to decide. Therefore, I have used the comment.
Okay, let us see.
If your Lordship will kindly come to page 54.
Page?
Page 54.
54. Yes,
This is 26/4/2024 by the District Commissioner. I'm just reading, Lordship. The subject regarding allowed to lift the entire quantity of rice under NFSA by the Secretary of the Dakshin Business Samabay Samiti. So, Madam, in inviting reference to subject secretary of, I am enclosing the letters. The letters are here. The second last paragraph. Therefore, you are requested for a prompt compliance with the instructions provided in the government letter, allowing MS Dakshin Business Samabay Samiti located at Ananda Bazar to lift the full quantity of the said rise as specified. And then if your lordship will see the next page.
No, no, you are allowed, no doubt. But I want to know the basis for which you have been allowed. What
No,
is
these-
it that settled position of law that you are saying, or the
Yes.
settled practice that has been followed?
Yes.
Show me that. Show
But
out the
I
way.
think it will not be objected to by the other side. If it is not objected to the other
No, no,
side,
but then you see that doesn't mean.
if the government accepts that yes, this is the process, then I
No,
think it makes
he-
my case a bit easier, at
he-
least for a motion stage today, your lordship.
Maybe, but then at the end of the day,
I was relying on him. If he can be, this is the modality followed.
but then yes,
This is the modality followed, lordship.
Lordship, here I am appearing for the BPC, and Lordship, our decision is based on the speaking order issued by the commission. I am taking.
you see, the question is, can a committee say in the Panchayat A area lift food grain for the fair price shop in Panchayat B area?
Without there being any default at my behest.
Let-
At my end.
Yes, what he's saying that it is what did you say? It is a
It's a prevalent practice.
it is
admitted
a
and
practice
accepted by the
followed.
government.
It is
It's
a practice
it's
followed
their
and
policy.
accepted by the government.
Because
Now,
I never thought that.
How do you, is it correct? Is that submission correct?
Well, that- but as you're not told, it's a prevalent aspect of that. Well, that's not-
No, you see, prevalent practice it may be a practice, but then that does not mean that there is a bar for, there is a bar for a committee of Panchayat A to lift food bills for Panchayat B area. So you have to be, you have to clarify this issue. This is the core issue.
My
Maybe
case
some,
only.
Lordship
Huh?
dispute or complaint, whatever in that situation, maybe Lordship the nearby.
Huh?
If there is any dispute or complaint against that one particular committee, Lordship, then the nearby area will have to be allocated the allotment of that.
Why?
area
How?
because
On what basis?
Otherwise, the benefit.
On what,
will be
on what basis?
better.
On what basis are you saying that?
Because it's a temporary arrangement, Lordship, the order.
No, you
says
see, it's very simple. There is a Panchayat C also, there is a Panchayat D also. Why a committee of a particular Panchayat? Why not of committee of Panchayat C? Because they are making money out of it. It is not that they are doing it for free.
Yes.
So
maybe,
if you
Lordship, that
are,
distance factor is
if you
also
are given, but say that,
Maybe-
where is that?
Maybe,
Still-
maybe Lordship.
So
what's-
when there is, huh?
There is, the last portion of that order, that in connection with last purpose.
Yes.
That,
Page 73,
yes, the second portion in connection with subdivision of the special for an order. Just because of the dialogue.
where are you reading? Page 73 is the order,
Or
last page,
last page,
annexure 16.
6,
Yes, which line?
temporary last, in connection with the
Fourth line from the
fourth
bottom.
line. In connection with the business paper, in purchase of the coach order, allocation order. So, the allotment of the customer is hereby entrusted to FS for the access certificate. Area temporary for the smooth fixed NFSA right as per copy of the completion of the credit process.
So that is what, now that is what I don't understand. Now, if there is a tendering process, then where is the question of the normal practice? If there is, because he said, petitioner said, that there is one committee for one panchayat. If there is one committee for one panchayat, and if it is the normal practice that one committee has to be given the carrying contract, where is the question of a tendering process? Who is going to be the tenderer?
So tenderer will be a private contractor. That is a separate process altogether.
That's a different process.
Yes, Lord. Because moment a private contractor through a tendering process enters into the scene for lifting of transportation, the GPSS secretary level will be now out of the scene. That position, when it comes, I have no case.
Yeah.
But my case is today, till that contractor or the tendering process has not been introduced or not been placed into practice, I have a right, because the allotment was given to me.
Again, back to
Let-
square
let-
one.
Let me just complete. Let me just complete. I have a I have a right because there has been government orders in my favor, where I'm coming in my favor. Now, if it is a practice, even if I practice, the benefit has to come to me, and I can be deprived only therein, where there's a default at my end.
No.
There is no default at my end.
Where do you say that? How do you say it's a practice? Where is the basis for saying that?
The government orders giving me the right to live. If a lawsuit will come to the page 54, 55, there are orders in my favor, which I'm trying to pay for lawsuit. Page 55.
This is a monthly allotment.
That's it.
This is not yearly allotment for 10 years or 20 years or forever. It is only a monthly
So
allotment.
the outer limit will be till a contractor is appointed, as written reflected in the order itself. The lawsuit will kindly bear with me for 5 minutes. Just one thing, page 55. What I am trying to plead for lawsuit is that, leaving apart the rules or
You just show me the policy decision, and that this is what is followed everywhere. Then you have got a case. But just because you are saying that is a practice does not give you any
my
right.
urgency is today a third party is going to live in the month of August, who has got no role at all in this entire dispute, because who were against me is now out of the scene. They are not before us now. They have been totally sidelined by the court, honorable court, as well as the authorities. How can a third party be given the benefits now?
I do not know. I do not know if it's
So
a
that
third
is
party.
why I need some protection. If a lawsuit will kindly say page
No,
55.
no, you have to first clarify your point.
My
As
case
to how-
is
You please show me that it's only you who have a right to lift the food grains.
in so far as the quantity allotted to me.
He says that he doesn't know. They're not supporting you.
No, I'll try to clarify on a different aspect altogether. The rule, the statute stands in one footing, obviously. The other would be a practice that I'm referring to. Now that practice is reflected by the
Practice doesn't give you any right.
no, I understand. The practice is reflected by the decision of the department. The department has given me an order. At least I have some right basing on that order, page 55 lawsuit for a moment. I'll just 5 minutes, I'll complete my argument, I'll leave it to your lawsuit thereafter. Page 55. In pursuance to government letter such and such, you are hereby allowed to lift the entire quantity quota of PMGKY rice under NFSA. But you have seen that. This is giving me one right. Then, if a logic will kindly quickly come to page 70.
No, but another thing, how did he give you this order?
Yes, that is.
How is this order? How is this order was challenged? Correct.
Yes, it was challenge,
That now,
not interfered.
no, not interfere. But then the question this court is saying, how did the authorities give you this order? On what basis?
There are these documents are there. If your lawsuit will listen to look at the documents are there. Also, the actual order is at page 53, which is issued by the commissioner. There has been a lot of communication interdepartmentally pursuant to our application saying that we are now economically well off. I can lift my entire quantity. This is the initial order, the parent order, page 53, 18th April 2024. The last paragraph also will see. This is the commissioner's order.
Huh?
This is the commissioner's order.
Maybe.
Because he is the highest authority, Lordship.
Maybe. But
Yes.
then I want to know how he has exercised his power. You see, there has to be a source of power for exercising it. Now,
I
what is the
understand where
source
your
of what is the source of power that he has exercised to allow you to lift food grains?
Because it was always been lifted by me. The allotment order I have shown to your Lordship. There was a point of time when I said I will not
You see,
lift the entire
all this
quantity.
is so that this court can learn.
So
okay.
I will
You
definitely assist your Lordship.
you are saying that this is the practice. Now, please show me the basis for that practice. It
My-
cannot be on the whims and fancies of the government.
My argument
Today,
would be-
today they are giving it to him. Today to the other person.
my argument would be subject to correction. These orders were put to challenge before this honorable court, and this honorable court.
But this question was not asked. This question that this court is asking today
but-
has not been asked earlier.
the
Has it been
legality-
asked?
But the legality of this order was challenged. So
No,
probably.
no. But then we can still open up this
Yes, it's
issue.
obvious.
Then-
That is always open.
Then?
That is always open.
Then?
Just to maintain judicial discipline, I was trying to make that point forward. Just to say, what
I understand your issue, but to give a reasoned order, I need the basis
the
for
reason
giving.
also reason order would be departmental orders were in my favor. Subsequently, I was deprived by an order where there is no reasoning. The order does not speak of any reason as to why I have been deprived, and a new party, a third party, has been given the benefit. Page 72 for a
No,
moment.
that much I understand. I understand the issue.
Yes.
But for me to give,
This order is a mechanical order. It has to reflect the reasons behind it. Even if we leave everything else, I was entitled.
where is the, which is the Tribune order 72 and 73?
72, yes, Your Lordship. And the honorable court order is just 2 pages behind.
Yes. He has some homework to do.
I'll do that.
Now I'm asking you. The petitioner and those 3 fair price shop dealers, you have to decide as to whether the arrangement was to continue or whether he was to lift the entire food grain. Now, why did you give it to a third party?
Government can only decide.
The story of 2 tigers fighting and a jackal taking the meat, something like that. This
But
new
the- but
party
the-
is completely not in the picture.
Maybe, but you have got to show that your right has been violated also.
Yes, because there are departmental orders in my favor, which has been
Departmental
violated.
orders without any basis do not give you any right.
That is again subject to an adjudication.
Correct. That's why this is today I'm asking you that question. Because I have got to be satisfied also.
Yes. But then if a lordship will see the order itself on the face of it, it is a mechanical order. It does not give a reason. What does it say? It says that the parties have to
Anyway,
compromise.
right. Heard.
So the only thing is that now third party is going to leave something that is actually belongs to us, and they are going to take the benefit of that. And we are not saying that we will not be able to live. In fact, we are lifting and we want to live.
But at the end of the day, this court is not really bothered about whether you're going to make some money or you're going to make some money. The entire purpose of giving ration is that the common man has his daily bread.
Competent to do that. That is why the authorities gave us the order. Our competence has now been dented by this order because they say you do not live.
Again, back to square one. You show me how your right will be.
I understand. Lordship. The only thing is that lordship, subject to lordship are going to give me a stay order, then please subject to outcome because this is a monthly order. Next month there will be another press order. At least that will be open for me to challenge by bringing those policies for lordship.
If you can bring this policy, then that's the end of the matter.
And lordship will keep it for instructions, and the interview will be considered on the next date, lordship.
Heard Mr. A. Sharma, learned counsel for the petitioner, who submits that the petitioner society was entrusted with the task of lifting food grain from the FCI godown to the Samiti godown and thereafter to be distributed to the
Fair price.
142 fair price shops under the which panchayat?
This is Coop South Salmara, lordship.
Under the South Salmara,
South.
very huge. Which
It's called South Salmara only.
Huh?
That allotment order, lordship.
so it is not based on any panchayat.
No, sir.
So the allotment is based on panchayat or not? Panchayat area or not?
Yes, lord.
Which panchayat?
It is given in the order. South Salmara, lordship.
Under the no, in the area covered by
Salbari.
the South Salmara,
Salbari, lordship. Salbari.
Salbari,
To
Salbari Panchayat, under the South Salmara district. Is it?
district Baksa.
In the under South Salmara district Baksa. Super.
Salbari, lordship. Not Salmara. Salbari.
Salbari,
Salbari district Baksa.
Salbari district Baksa.
Baksa. Not Salmara. Salbari.
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 Now which panchayat?
Salbari. Salbari subdivision. It is called Salbari subdivision. Base 52, it's there.
Mr. Council, a subdivision can have many panchayats. Which panchayat are you talking about? Because the entire case is that a samiti of one particular panchayat
Yes, Lord.
can lift grains only for that panchayat.
My instruction is it is South Salbari Panchayat, they call it. But possible, give me a moment. I'll clarify. I'll clarify that one. I'll just give that name.
What have I said? Covered under the dash panchayat area. So district, Salmari district, no?
Salpadi.
Salbari district, Baksa. Next para. The petitioners council submit that in every panchayat area, there is one
Gaon Panchayat like Samabhai Sabhi.
there is one in every panchayat, in every non-panchayat area.
Gaon Panchayat.
There is one, what?
Gaon Panchayat Samabhai Samiti.
So there is one Gaon Panchayat Samabhai Samiti, which
One
is
panchayat.
responsible for lifting food grains from the FCI and distributing it to the fair price shop dealers in the particular Gaon Panchayat area. Pusta. He submits that the petitioner society had been entrusted the task of lifting food grains from the FCI godown and distributing the same to the fair price shop dealers since the year 2020. However, as the petitioner was having some financial difficulty during the COVID-19 pandemic, the secretary of the petitioner approached the respondent authorities to have the lifting of the food grains done by some of the fair price shop dealers. Accordingly, which are there parties here? Accordingly, the respondents number
Yes, Lord. So their party is here.
9, 10, and 11 bracket fair price shop dealers were allowed to lift food grains along with the petitioner for distribution in the which Gaon Panchayat area is this? In the which Gaon Panchayat area?
Same Gaon Panchayat area.
What is the name of that Gaon Panchayat?
My instruction is South Salbadi Gaon Panchayat, but I will clarify that.
In
one.
the South Salmari Gaon Panchayat area. Pusta. Next para. The further stand of the petitioner is that sometime in the year, when 2024, when
2024, yes, Lord.
when
Just placing that. Phase. Possibility, phase 49. Phase 49. It's on 16th February 2024.
that
Our application was first considered on that day.
where is your letter to them?
That is not annexed, but this letter indicates about our application. That is not annexed.
Submits that sometime in the early 2020, sometime in early 2024, the secretary of the petitioner wrote a letter to the respondent
Paragraph 4.
stating that they were in a position to lift the entire food grain for the said Gaon Panchayat area. Pusta. Acting upon the representation made by the petitioner,
53.
the Commissioner, Food, Civil Supplies, Consumer Affairs, and Legal Metrology, Government of the Stamp, wrote a letter dated 18/4/2024 to the Commissioner, Food, Civil Supplies, and Consumer Affairs, and Legal Metrology, requesting him to allow the lifting of the entire quantity of the PMGKAY rice under the NFSA by the petition. Accordingly, necessary orders were issued by the respondents, allowing the petitioner to lift the entire quota of PMG KAY rights. Being aggrieved by the said orders, the respondents number 9, 10, and 11
Yes, sir.
approached this court by way of WPC 2540 of 2020,
65.
stating that an agreement had been entered into between the petitioner and the respondents number 9, 10, and 11, whereby the lifting of food grains by the respondents number 9, 10, and 11 was to be done for a period of 1 year. As such, the lifting of food grains by the petitioner, the lifting of the entire food grains by the petitioner should be set aside. This court disposed of WPC, that's next para, 2540 of 2024 by order dated 15/5/2024 by directing the respondents number 9, 10, and 11 to submit a representation to the authority, whereupon the authorities were to take a decision upon the representation of the respondents number 9, 10, 11, and after giving an opportunity of hearing to the petitioner hearing. Subsequent to the directions passed in the order dated 15/5/2024 in WPC 2540/2024, the
70 allotments were issued.
state respondent,
Page 70, pursuant to even this order, allotments were given to us, page 70. Full allotments.
the state respondent issued the impugned orders dated 13/6/2024 and 10/7/2024, whereby the lifting of the NFSA rights, no, the lifting of the food grain was for lifting of food grains for which area? For the, what was that, Gram Panchayat area?
That's not, that's,
Whereby the lifting of food grains for the said Gram Panchayat area
in fact,
Was-
they are also
was-
saying concerned area of.
was given to the respondent number 8,
Eight.
who is not, which is not a, what is it? SSB, no, it's a Samarbhai Samiti,
That is a Samarbhai Committee, but not within our
which
jurisdiction.
which is a
And it's
Gram
maintained
Panchayat Samarbhai Samiti, not within the area covered
Our
by
Petitioner
the
jurisdiction.
dash by the concerned Gram Panchayat area. Concerned by. The petitioner counsel submit that the respondent authorities could not have allowed a third party, that is the respondent number 8, to be given the task of lifting of the food grain for the concerned Gram Panchayat area. When the issue was to be decided, when the said issue was to be decided between the respondents number 9 to 11 and the petitioner.
Why it was given to them, there is no reasoning to that effect. What is our default? That is, there is no reasoning to that.
On a query text para, on a query raised by this court as to the basis for the petitioner taking a stand as to why GP, a Gaon Panchayat Summit, Samarbhai Summit can lift food grains only for the particular Gaon Panchayat area where the GPSS is located in, the petitioner counsel submits that he needs some time to produce the report. Issue notice returnable in, well, in 2 weeks.
2 weeks.
In 2 weeks. Mr. B. Chowdhury, accept notice on behalf of
5 and 6.
Respondents number 5 and 6, while with view the accept notice on behalf of 1 to 4 and 7. Petitioner takes steps for service of notice upon the respondents number 8 to 11 by a registered post agent within the course of the day. Next para. In addition to the above, the petitioner shall take steps for service of notice by way of justice service upon the respondents number 8 to 11 within 10 days and file affidavit of service thereafter. Yes, anything to say?
Kind of, because of temporary and the order issued for the month of. Order. Month of course of temporary. So. Okay, start.
Today's what day? Or 2 weeks. Is too late now.
That's it.
It's too late now.
For the month of August, they will leave.
Yeah. Right.
September, at least I can do something.
List the matter after 2 weeks. Give a date. List the matter when.
After 15th of August, any date.
Huh?
After 15th of August, any date.
Please about it. Why so late?
This is today's 23rd. I'll leave it to you launch it otherwise. Because what I was thinking is next allotment will be in September. So before that,
No, let them all come and file their affidavit. Also.
yes, any launch it.
Okay, 12th of April. List the matter on 12th of April.
Interim will be considered on that day if that's possible.
Oh, earlier than that. List the matter on 8th of April. You see, actually, if you can produce, if he produces the policy decision on the basis of which a GPSS is allowed to live for grills for a particular GPS, Gram Panchayat area, then that solves the entire case.
I have to show my right, basing on which this.
That's all. That's all. Once you show your right,
Yes.
then
I was
Yeah,
thinking it a bit casually this time because I thought because they will be admitting only. So then this is the prevalent practice.
they're,
I will get that policy.
they're very smart. They're not admitting. This is a matter of need, huh? On the subject, the issue of whether the respondent number 8 can continue to live footprints beyond the month of August 2024 shall be decided.
Deeply obliged.
Maybe decided, say maybe decided, but sometimes something are not good.
Petitioner is a civil engineering consultancy company, my lord, and it's achieved by the order of termination of a contract.
Show me a termination order.
Yes, lord. Page number 53, my lord. Also not a simplicity of termination of one contract, my lord, because it is a practice.
Let us read the termination order.
Yes. Page 54, my lord. Annexure 1, page 53.
Yes,
And the operative part is, my lord, page 57,
yes,
para 16.
yes,
In light of the aforesaid non-exhaustive fundamental breach and in view of the consultant persistent sustained gross default in fulfilling the contractual obligation, the authority is left with no other option but to terminate this contract in accordance with provision of 2.9.1 of the GCC of the contract agreement on account of consultant's default with immediate effect. Upon termination of a contract on account of consultant default, the relevant provision of the contract agreement will henceforth apply. In pursuance of this termination order, your firm shall perform no further services other than those reasonably necessary to close this one.
So,
my lord, this is not a simplicity of termination of one contract. My lord,
no, show me where is the termination of other contract. This is the termination of this contract.
is this contract only, my lord, but I am aggrieved because there is a condition in the NIT of every department, every organization, which are placed on record, my lord, a series of, my lord, I have point,
No. So which you see, I don't want the series. Which tender were you trying to participate in?
my lord, page 151, my lord, Annex 13. Even respondent don't allow, my lord. I will show the respondent's NIT also. Page 151, my lord.
Yes.
This is RFP request for proposal for selection of supervision and quality control.
When was the last date for submission of the bid in this
But this NIT is of January 2024.
24? When was the last date submission?
Last date of submission. I'm only quoting, my lord, the examples.
Mr.
of-
Counsel, let us go. You see, you want to participate in a tender process, correct?
Yes.
Now, which tender process did you want to participate in?
Lord, I'm not able to participate anywhere, my lord.
Show me, which tender process were you planning to participate in? You're planning to participate in this tender
Yes, my lord.
process
I
on
have
page
given that,
151.
my lord. I've
Now, when is the last date of submission of bids in this?
my lord. Lord, I have given the entire list of the tender which I was proposing to file, my lord. Page 18 of my red petition, my lord. I've given in tabular form, which all tender.
No, you first answer my question. It's page 151.
Yes, my lord.
When is the last date of submission of tender?
The latest RFP is of July 2024. That is by the respondent, page 183. This is the latest, my lord, we wanted to participate, but now we cannot participate. Page 183, my lord, written July 2024.
Mr. Counsel, let us not jump from one. The question is, this page 151.
Yes.
What is the last date of submission of tender?
Lord, this date must have passed on because this is of January. There is a 2-month, my lord, period for participation.
So you have missed the path.
No, there are others, my lord. I am
Yes,
only showing the
now-
example.
No, you show me. Where is the clause?
Yes.
In page 183.
183 is the first page, my lord. 184, para 18.
Yes.
May I read, my lord? The bidder, including individual or any of the joint venture members, should in last 2 years have neither failed to perform for the consultancy services pertaining to the Expressway, National Highway, ISC, EI, work as evidenced by imposition of penalty by arbitral or judicial authority or judicial pronouncement or arbitration award against the bidder, including individual or any other joint venture, as the case may be, nor has been expelled or terminated by Ministry of Road Transport or its implementing agency for breach of such bidder, including individuals or any of its JB members.
So, Mr. Counsel, the only thing now is that if you are agreed with this term and condition,
Yes, sir.
challenge this term and condition. Challenge this term and
there is-
condition.
This condition is there in every organization, every.
So you
sector.
challenge in each and every now you see. This is what you're trying to say is that in effect that no one can terminate anyone. That cannot be allowed.
No,
Now,
there are-
just let me tell you, in your case, there's been a termination.
Yes.
Is there any arbitration clause in
Yes.
your?
Yes.
Have you availed of that arbitration
No,
clause?
Lord. Lord, I'm relying on the.
Have you challenged the arbitration, the termination order in any court? Have you put to challenge the termination order in any court?
Lord, that is why I'm here, my lord.
No. Have you challenged? You have challenged it here?
Yes,
On what ground? Only on the ground that you have not been able to participate in any other tender. It's
The-
not on the ground that this termination order is wrong or something like that.
no, my lord, there are other grounds also, my
Show
lord.
me, show me, show me. Let us see your petition.
Where are the, sorry, my lord, arbitration clause?
Show me on what ground you have challenged your termination order in this petition.
My lord, my first ground is that the so-called notice is vague, my lord.
Come on.
It fails to point out the alleged breach which we have done, my lord, on account of which, my lord, respondent was contemplating for termination, my lord. Lord, may kindly see the so-called.
Okay, where is the arbitration clause?
Yes. Lord, 2.9.6, my lord,
Page,
page 102. Arbitration agreement is at page 112. Settlement of dispute. Clause 8. There it-
yes,
My lord, this issue cannot be decided in arbitration because there is a violation of fundamental right of the petitioner, my lord, to participate in the government contract, my lord.
no, no,
It can be dealt only under the,
you have not been debarred, you have not been blacklisted.
my lord, it is akin to blacklisting because I cannot participate in any of the tender, my lord.
No, no,
My lord, I can show series of the tender document where there is a specific clause.
it is there, no doubt, but
Yes.
you challenge that clause
My lord,
whenever you come under, you come, this cannot
there
be.
are 100 organizations, my lord. I have to challenge all the.
Naturally, but it's not a case that you're going to participate in all 100 contracts.
But here I am, my lord, because the so-called notice is vague, my lord. Kindly see the so-called notice for a moment, my lord.
Yes.
Page 132, my lord, annexure 10. And please see the ground, my lord, they have taken in the so-called notice on which they wanted to.
Yes, there is 130.
Page 132, my lord. I will straight away come to the operative part, my lord. Para 19 and page 135. Whereas the authority under clause 2.9.1 F of the GCC. My lord, this is the clause on which they wanted to terminate my contract. If the client in its sole discretion and for the reason whatsoever decides to terminate the contract. There are, my lord, 7 grounds on which termination can take place, my lord, out of which one of this ground was there, my lord. How do I know, my lord, that what allegation they have against me? My lord, may please see the contract, my lord, page 98 and 99.
Yes, madam, what is the reason? What is the show cause notice? He's saying that it is vague.
How it can be vague, Lordship? They failed to mobilize the key personnel on site
from the date of acceptance of the bid.
Key personnel were not mobilized on site.
Yes. So,
Where is that reflected?
yes, it is so good notification.
Show me where.
And also purpose notice, also the termination.
Show me where in the show
Yes.
cause notice.
Para 11 Lordship. Whereas the approval conveyed by headquarter lieutenant so for replacement of team leader, come senior hiring engineer, resident come hiring engineer, and senior quality come material expert. However, the consultant failed to deploy that team. And 12, whereas the PAMU before had data that is showing so the actual deployment of the team leader come senior highway engineer was from 22/6/22, but the individual has been absent since 87/22 to till date and having attendance only 4.3%. Then Lordship 13. Whereas the resident engineer joined the project site on 1/3/2023, but has been absent since 29/3/2006, having attendance 4.6 only. Similarly, senior quality come material expert joined on 21/5/2022, but has also left the project site since 1/3/2023, having attendance 47.17%. At present, there is no key personnel to mobilize at site. Till today, no key personnel that they have engaged lot. So site could not be mobilized. Even there is shortage of no arrangement for engagement of manpower in the site lot. So the project work could not go ahead. This is the construction of the road. They have failure on the to mobilize the key personnel. Without the key personnel, the project cannot go ahead lot.
But for this, we have already suffered the punishment, my lord, by deduction of my fees. There is a specific provision in the contract, my lord.
Moreover,
If
one
the
thing is
key
there.
professional is not there on the site for a
It is
required
important
period of
also.
time,
It's very
they will
important.
deduct my salary, my lord. My lord, kindly see page 110, my lord. There is already a punishment for this. Why termination, my lord? They have already given me this punishment, my lord. We have not challenged that. Page 110, my lord.
They failed to perform their duties of it. They have not mobilized the key personnel lot.
What was the time period for
Or
construction?
17 months lot.
No, what is the contract agreement say out there?
And that contract actually it's not clearly mentioned. But
What is the time period for completion of the work?
What?
agreement.
Construction period was 24.
They have not
When was the contract? When was the letter of
annexed
authorization?
the contract agreement, whole contract agreement.
Huh?
They have not annexed the whole contract agreement.
Correct.
That is the problem lot.
But the
Only have
contract
to
agreement is
our
at page 119, my lord.
And also one thing is there, we have given them so far. They have not replied to also
Lord, I will answer for that.
without
What show cause for what?
for termination.
Okay.
Before termination.
Show cause notice.
Yes.
Dated
19/10/23.
19/10/23, page 132, Lordship. Everything has been mentioned in the so-called notice,
not replied.
not replied, till date of termination, Lordship. Why they have not replied?
My lord, I have
There should
answered to
been
that. I have
so-called
made
notice.
that submission in my petition also, my lord. My lord, this company was under, my
Petition,
lord,
if they make submission, people what before.
my lord, there was a change of management in the company, my lord. The company was admitted by NCLT, my
When was
lord,
the
Delhi.
when was the contract agreement signed?
21/10/2021.
21/10/21. So you are supposed to complete your work by 23.
No, my work is for supervision, my lord.
Oh.
Construction will be done by the contractor. I have
But
to
then,
supervise that.
so the if supervision is not there, how can work be done?
My lord, for that, there is a specific provision in the contract for deduction of my salary, my lord. Kindly come to page, my lord, 110, my lord. That punishment we have already undergone, my lord.
Huh?
That itself in the contract, Lordship, page 132. The consultant is officer for supervision of that widening and improvement of 4 lane with paved shoulder from so and so. They not supervised properly, Lordship. How that
My lord,
project will
So the work has not been completed till now. Then
no, my lord.
Work is not completed.
Because their, due to their failure, lordship.
No, they have appointed someone else, my lord.
Naturally,
They have
when you have
appointed.
not done your job.
Lord.
I remember when we were building the Aizawl bench of the Guwahati High Court, we ensured that there was supervision. Without supervision, we did not even allow the contractors to work at night because at night the supervisors to go to sleep, go home.
Lord, allow me to answer the, my lord, permission which was offered. My lord, there is a
No
specific
case.
provision in the contract, my lord. If there is a non-deployment of key professional, my lord, there is a provision of deduction
You
of
go
my,
to arbitration, there's arbitration clause.
my lord. Kindly come to page 110, my lord, and please see who are these key professionals, my lord. Lord, may kindly appreciate who are these key professionals.
There's an alternative remedy available.
My lord, how they are appointed? They are not my employee, my lord. My lord, there is a procedure set by them only that we have to engage a consultant, my lord, from the website maintained by the Infracon. This is their society, my lord.
Mr. Your name is
Rajiv Ranjan Raj.
Rajiv
Ranjan Raj.
Rajiv Ranjan Raj, Learned Counsel for the petition. Your name is not here in the.
My lord, I am out station.
But where is your Wakalatnama? Without a Wakalatnama, why should I hear you? Are you a senior counsel?
No.
Then? That Mr. Rajiv Ranjan Raj, Learned Counsel for the petition. Along with Mr. M. Gautam. No, don't put him. Put only him. Also heard, no, right. The petitioner's case is that no, the petitioner is aggrieved with the termination order dated 24/4/24 issued by the respondent number 3, whereby the petitioner's contract as the petitioner's contract providing consultancy services for supervision of widening/improvement to 4-lane with paved shoulder from KM 95 plus 400 to KM 113 plus 330 near Ganpat Gaur Gaon to Kwaram Taro village section, package number 5 of NH-29 in the state of Assam under Bharat Mala Pariyojana on EPC mode was terminated. In terms of clause 2.9.1. 2.9.1 of the general conditions of one. This is at page 77, huh? No, not 77, sorry. Page 132. That the consultancy service. Okay. The petitioner's counsel submit that the show cause notice dated 9/10/2023, on the basis of which the impugned termination order has been issued, is vague, as it fails to point out the alleged breach on a breach of contract on account of which the services of the petitioner have been terminated. As such, no opportunity of being heard on a relevant point was given to the petition by the show cause notice dated 9/10/2023. Next para, the petitioner's counsel submit that in view of the termination order dated 24/4/2024, the petitioner has not been allowed to participate in other tenders, as there are clauses in various tenders wherein parties who have had their contracts terminated are not allowed to participate and are not considered for award of the other contract work. He submits that the impugned termination order dated 24/4/24 is akin to blacklisting slash debarring the petitioner. And as such, the impugned termination order dated 24/4/24 should be satisfied. In this regard, he has relied upon the judgments of the Supreme Court in the case of Gorkha Securities Services versus Government NCT of Delhi and others 2014 9 SEC 105 and UMC Technologies Private Limited versus Food Corporation of India and another 2021 2 SEC 551. He also submits that the termination of contract of the petitioner only because the petitioner had not allegedly been able to post key personnel for supervising the contract work amounts to inflicting penalty disproportionate to the offense. In this regard, he has relied upon the judgment of the Supreme Court in Pulja Industries Limited versus Western Telecom Project BSNL 2014 14 SEC 73. He accordingly praised that the impugned termination order dated 24/4/24 should be set aside. Mrs. R. Bukar,
Bora,
Bora, appears for the
question number 20,
2 and 3.
NHID.
Appears for the point number 2 and 3. Who else is appearing? While Ms. B. Devi, R. Devi appears for the point, CGC appears for the point number 1. Good, sir. The counsel for the respondent submit that submit at the outset that as there is a arbitration clause in the contract agreement between the parties, the petitioner would have to avail of the arbitration clause for making a challenge to the termination of the contract between the parties. They also submit that the show cause notice, no, the counsel for the respondents number 2 and 3 submits that the show cause notice dated 19/10/2023 issued to the petitioner is not vague. And the same clearly shows that despite shows that due to the petitioner failing to deploy key personnel for consultancy services for supervising the road widening contract, the said road widening contract work has not been completed till date. Correct. She submits that. She also submits that the show cause notice dated 19/10/23 on the basis of which the termination order had been issued. Respondents number 2 and 3 was not replied to by the petitioner. As such, the petitioner cannot now agitate that the show cause notice was vague or that it did not have any material particulars. Anything else?
Okay, so but proposed notice could not be replied because there was a change in management. My lord, company went into national
That
company
is
law,
the difference.
tribunal, my lord, and RP, my lord, took over the management of the company, my lord.
I think
So that was
whatever-
the actual reason, my lord, reply could not be given. my
Maybe,
lord,
maybe.
Because there was a change. I placed on record the order of.
Maybe
SPSC of
at the end,
11th of January.
anyway, at the end of the day, you take that up with the division bench.
Lord, as per,
Right.
Lord,
I have
as
heard,
far as the arbitration clause, my lord, I am relying on two judgment, my lord. I have mentioned in my petition,
I have heard,
Tantia Construction, my lord, as well as the Whirlpool, my lord, where there is a violation of fundamental right, my lord, writ petition is maintainable, my lord. Because my fundamental right to participate in the government tender is violated, my lord. There is a, my lord,
I have heard the learned counsel for the party. As can be seen from the submissions made by the parties, by the counsel for the parties, and the amendments made in the writ, and in the and the and the and the and the and the and the writ and the contents of the writ petition, comma. The petitioner was given the contract for consultancy services for supervising the widening of a road contract work given to some other contractor. A contract agreement was signed between the parties on
5110.
21/10/2021. Signed between the petitioner and the respondent authorities on 21/10/2020. The show cause notice dated 19/10/2023. That is approximate. Wait, what have I said? That contract agreement was signed on 21/10/2021, and the and the and the contract agreement was for a period of was to be valid for a period of 2 years. So, sir, 2 days shy of the 2 year contract period, comma, that is on 19/10/2023. A show cause notice was issued to the petitioner by the respondents number 2 and 3, stating that the petitioner had failed to perform its duties and responsibilities by not mobilizing key personnel at the site to supervise the road contractor. Para 11, 12, and 13. Para 11, 12, 13, and 18. 18 and 19. Eighteen, 19, 20. Of the show cause notice dated 19/2023 is reproduced here and below as follows. Page 133 and 134. The petitioner, however, did not submit any reply to the show cause notice dated 19/10/2023. Subsequently, the impugned termination order dated, where is the termination order?
Page 53.
Basic.
Page 50.
Page 53.
24/4/24. Next up.
Dated 24/4/2024 was issued, whereby the contract between the petitioner and the between the petitioner and the respondent in HIDCF was terminated, as can be seen from para 14 to 19 of the impugn termination order, which is as follows. Page 57 and 58. The next para. In view of there being an arbitration clause in the contract agreement between the parties for resolution of disputes between the parties, at clause 8.4. No, just like that. In view of there being, in view of clause 8.4 of the contract agreement providing for arbitration for resolution of disputes between the parties, this court is of the view that the parties, that the petitioner would have to avail of the arbitration clause for making a challenge to the impute termination order. Clause 8.4, 8.4.1. And 8.4.2 of this contract agreement is reproduced herein below as follows. Page 113. No? Next up. The next question to be decided is as to whether the no, next up. The petitioner's counsel has also taken a stand that the termination, the impute termination order is a blacklisting / debarment order, which does not allow him to participate in other tenders. A perusal of the impugn termination order, however, does not indicate that the same is a blacklisting / debarment order. Though the petitioner has uh, uh, annexed 2 tenders, which apparently does not. No. Where is the debarment order in debarment clause?
Clause, my lord. Lord, first clause is at page 156, my lord. 6, para 5, my lord, eligibility, 5.5. if any proceeding, suspension, cancellation, registration of, or for blacklisting, or for termination of contract due to poor performance by the consultant.
Right,
association.
what have I said? Two tenders. Which bars?
What it ranges from
Which
2
bar?
years to 6 years.
Which bars? Which bar? Which bars the petitioner from participating in the bidding process due to the petitioner's termination from a contract in terms of the impugned order stated twenty-four for 2024. This court finds that the petitioner has not put to challenge the said clause in the tender where he has, where the petitioner has been barred from participating in the bidding process. In any event, the termination order, in the view of this court, the termination order, impugned termination order is not an order of is not an order blacklisting the petitioner from participating in any future tender.
May I just clarify one?
In view of the reasons stated above, this court does not find any ground to exercise the discretion in this case. The writ petition is accordingly disposed. I will make some corrections here and there later.
Not only one clarification, my lord. These key professionals are not my employees. They are, my lord, they are consultant. We only recommend their name. They approve it.
Why didn't you file a reply to the show cause?
My lord, the reply for the reason I have mentioned, my lord, that company was not, my lord.
You go to arbitration now, too late.
My lord, it is a blacklisting for 6 years, my lord. We will not be able to participate.
Where is the blacklisting? Where is the
If I
blacklisting?
am not able to participate, that is blacklisting.
You
If my
challenge-
participation is barred, then it is a department order, my lord. And the key professionals are there, my lord, expert, my lord. We only recommend, my lord.
My lord, the pleadings are completed, my lord. Either to, my lord, treat the matter for hearing, my lord, and or my lord, refer the matter before the arbitrator, my lord, because there is a arbitrator clause in the agreement, my lord, page 24 of the writ petition. Just to clause 26, arbitrator. Any dispute and question in connection with the partnership or the. Look, Mr. Counsel, you withdraw and you avail of the arbitration clause. Yes. You withdraw and avail of the arbitration clause for the simple reason that the respondent number 4 has said that it is disputed question of fact. But not of. So this writ petition we cannot decide when there is a dispute. That is how, my lord, then, my lord, let the matter be listed for hearing, my lord. I will decide now. I will decide now if that is the case. I will dismiss this case. Because you said disputed questions of fact. Because, my lord, the power of attorney is found by the, my lord, LS to be executed by the partner one, my lord, is not binding upon the firm, my lord. Look, Mr. Counsel, this is a case for payment of money. Yes. Outstanding bill. Now they have said that this is a disputed question of fact. When you go to civil court. There is no disputed question of fact, my lord. Why? Because, my lord, the alleged power of attorney executed by the partner on, my lord, on his behalf, my lord, not on behalf of the firm, my lord. My lord, kindly come to the power of attorney, my lord. Yeah, why don't you go in arbitration? This is evidence will have to be required.
My lord, because
Evidence will have to be taken.
my lord, come to place, my lord,
Mr. Counsel, it's very simple.
Yes.
This is a question regarding payment of money.
Yes.
Correct? Now, and when they are disputing fact, then evidence will have to be taken.
my lord, there is no any dispute, my lord. Because, my lord, the alleged power of attorney executed by the partner on his own capacity, not on behalf of the firm, my lord. That is why, my lord, there is no disputation of fact. Law is clear, my lord, that part, my lord, there is a judgment of the Honorable Supreme Court, my lord. When a partner executed a power of attorney on behalf of the firm, that other partner is bound. But in the power of attorney, it is shown that, my lord, the partner one has executed the power of attorney on his behalf already, not on behalf of the firm. And law is clear, my lord.
We go to the
My
partnership
lord,
ideology, it will clarify. The partnership it has been specifically stating that the power has been conferred to his partner, number one partner, to appoint any person to work on his behalf. Before his death, he has executed a power of attorney to execute the unperformed part of the work, contextual work. That is why thereafter he has the response number 12 where I am appearing in your lordship. I have completed the work and completion certificate has been issued in favor of B. That is a sum of the disputed question of
My
fact
lord.
and examination and evidence and cross-examination will be required, your lordship, to come out of the truth, your lordship.
my lord, page 99, affidavit filed by the
You have for the respondent number?
12, your lordship.
12.
I have completed the work in view of the strength of the power of attorney, in view of the partnership deed conferred between the parties. The moment the one partner has died, your lordship, the partnership has come to an end. The petitioner has no locus to file these petitions. He has no, if you go for the terms of the partnership deed, there is no
Then
experience.
let us see the partnership deed.
Lordship.
Yes, my lord. My lord, page 76, my lord.
It is a partnership of will, your lordship.
If a
Absolutely.
partnership firm is not dissolved when the partnership firm is a will made. On the death of a partner. the
Just a minute.
Yes.
Let us see the partnership deed.
Lordship.
Moinul Haq and Moinal Haq.
Yes, two partners.
So who is the one who died?
The number one,
Number one.
Moinul Haq. And number four, term number four, duration the partnership shall be a partnership at will. And number 10, the management, your lordship. There is a specific page number 20, your lordship, the management. Page number 20, the management. The first partner shall be each person and solely authorized by the firm to perform all works in connection with the firm.
Which one? Where?
Page 20, the number 10 clause. Management.
Page 20?
Page 20 of the-
79, page 80.
The page,
Yes, yes, yes. Yes, yes,
It is.
yes.
page 80 of my 18 opposition.
Which management?
Management. For the first partner shall be the key person and solely authorized by the firm to perform all work in connection with the firm. And the next page 81,
Page 81.
page 81, para number 12, that all the charges, bill of exchange or promissory note, documents, and papers relating to the business of the said firm and affairs of the said partnership firm shall be signed, drawn, and accepted or endorsed by the said first part, that is the first partner. And in his absence, any partner authorized by the firm. That is the person who the party, the partnership deed has to explicitly write, whether express or impliedly given to the his number one partner to do any kind of work on behalf of the firm. That is why on the strength of this partnership deed, he has executed the power of attorney in favor of me. And I have completed my work and with the permission from the respondent authority. And I have completed unperformed part, who has been, because he, during the first part, he has fallen ill and several times the agreement has been for execution for only 12 months.
already first part delay has been caused due to the COVID period. First part has been completed by him. The money has been taken by first part. Subsequently, he expired. The partnership deed has been exhausted, Your Honor. Thereafter, I have completed my work and submitted my bills and the completion certificate also issued in favor of me. That is the
And money is still there with the department.
department.
Oh, you impleted yourself.
I'm impeded by my evidence that is,
You impleted yourself.
yes, got it.
You were not impleted earlier.
No, that is, I have impeded myself. Because I have learned from that verification and the pending hypothetical mode. The moment I have learned
Where is the power of attorney?
the power of attorney is page 899, Annexure H. The relevant portion is 100, Your Honor. To do complete aforementioned work as per specification of the said work on my behalf and my absence. There is a clauses and conditions, Your Honor.
Yes.
Page 100. The relevant paragraph.
Mhm.
To sign necessary and relevant papers for and on behalf of me and from the competent authorities to do all acts in connection with the aforesaid work, that is the contractual work, on my behalf and in my absence, to maintain all the day-to-day transactions of the said work and other all these necessary terms and conditions, which is in favor of me, Your Lordship. I on the strength of the power of attorney, which has been verified by the government leaders of the responding authority, and he has endorsed that his power of attorney is genuine. There is no doubtful it is at all. I have also annexed that the Annexure M, which is the verification report, Your Honor. Annexure M is 110. The 111 is the opinion, Your Honor. It's his opinion. In my opinion, the general power of attorney executed by the executive dated 6/5/2021 in favor of lawful attorney is valid, proper and correct and legal. Also, it is applicable in the eyes of law.
Oh, this page 110 is by whom?
Is a government leader, Your Lordship, who has been appointed for verification for that power of attorney and other documents, which is submitted by the deputy respondent authority.
You're Jiten Nazari.
I'm the citizen Nazari. I have completed the work. Since there is a serious disputed question of facts, Your Lordship, so the closest
The disputed question of fact is whether he should get or you should get.
Lordship.
Acceptable, that's not here in our application. But ask the court decided to whom this money will be. That is the today we pay up somebody. And tomorrow, my lord, the honorable court.
There is no question of arbitration here.
Yes,
Arbitration is not. It's a civil dispute.
There is a civil dispute.
My lord, we will get the money.
Correct.
My lord, come to page 99 of the power of attorney. Know all men, women by this general power of attorney. I am the Moinul Haq so and so have got a contractual or for
Page?
page 99, right?
Which para?
From top, my lord, starting from.
No, all men, yes.
Yes, I'm Moinul Haq so and so, my lord, have got a contractual work from office of the so and so for construction of so and so, my lord. Then, my lord, only. Then next, whereas I would like to mention here that presently I am not in position to perform the said work due to my personal inconvenience and other family problems. It is not possible on my part to do the aforesaid contract work for the other official work in connection with the aforesaid work for which I do hereby nominate, constitute and appoint so and so. Then, my lord, the clauses. To do complete the aforesaid work as per specification of the work on my behalf and absence. only, my lord, the power of attorney has executed, my lord, on his personal capacity, my lord, not on behalf of the farm.
Maybe now
Then, my lord, come to the agreement. Agreement, my lord. Partnership, deed, my lord. My lord, page 79, duration. The partnership shall be a partnership at will. Will has been defined by the section 7 of the Partnership Act, my lord. Section 7, my lord.
no, you see, there are two aspects. One is whether the the power of attorney is valid or not, that is a different issue. Now another issue is who really did the work? Did you do the work? Is
Yes,
it
my lord, as per my instruction, my lord, the petitioner firm has.
and as per his instruction, he did the work.
Page
petitioner
11,
firm
And
has-
as per the government instruction, who did the work?
That a part, my lord, the.
Annexure L, 109, is a completion certificate.
109.
109 of my opinion of question, Annexure L.
My lord, that a
Yes.
part on interesting thing, my lord,
And
the power of attorney, my lord, shown to be executed, my lord, on, my lord,
that Sri Jitan Nazari, power of attorney holder, name of the contractor, Moinul Enterprise. And progress report also Annexure K. My name has been
my
shown.
lord. On
NHR Cape, where is that page?
That is name of the column number 8, name of the contractor, Jitan Nazari, PA holder of Messrs Moinul Enterprise. And the progress of physical progress in 100%. That means
And-
I completed the 100% work.
Which page? 109.
108 is the progress report.
108.
8, the previous page. In the column number 8 is the Jitan Nazari, name of the contractor, PA. PA means power of attorney holder. Then subsequently the 109.
my lord. And the power of attorney, my lord, shown to be executed on 13th of February 2020, my lord. And the record shown, my lord, although the power of attorney, my lord, shown to be executed in the year 2020, but the petition submitted by the, my lord, partner on, my lord, for extension of time, my lord.
No, so all these facts show
Yes.
that they are disputed
No, my
questions
lord,
of
on
fact.
record, my lord. Page 93. Page 93, my lord.
You go to the division bench.
My lord.
You go in appeal.
And, my lord,
You go in appeal division. My view is that it should go to the civil court.
my lord, consider, my lord, only peruse the section 7, 22, 25, 35, 43, 6 and 43 of the Partnership Act. That will be perused, my lord. Section 7.
Right. I'm not going to verify. You go to
My
civil
lord,
court.
Peruse the provision of law, my lord. This is the law, my lord. Law has to
Heard.
be followed, my lord.
They have heard Mr. M. Hussain, learned counsel for the petition. Also heard Mr. R. Dhar, learned counsel for Mr. R. Dhar for respondents number 2 and 4. Mr. B. Sharma. R. S. R. Barwa for number 7. Mr. B. Chaudhary for 9, 10, 11. Mr. P. Nayak for 3 and 5. And Mr.
H. Purab for respondent number 12.
H. Barwa for number.
And against this, my lord, power of attorney.
The petitioner's case is that
Case already.
he was
submitted by the-
awarded a contract work with, please do not disturb anymore. Otherwise, I will have to pass some adverse orders against you. The petitioner was awarded, the petitioner's case is that he was awarded a contract work with construction of RCC, bracket 2-story residential. It is paragraph 2 and 3 of the order dated 29/4/22. Mr. Oh, your name is Mr. H. Barwa, learned counsel for the respondent number 12. Submits that the respondent number 12 had been given a power of attorney had been given a general power of attorney on 13/2/2020, whereby whereby the respondent number 12 was to complete the construction of a page 199, it is there, page 19 in between bread. He submits that in terms of the yeah, before 2 and 3 of that order, you just write that the petitioner counsel submits that the you say after the 2 and 3, after the 2 and 3, the petitioner counsel submits that the work had initially been done by the petitioner with one Moinul Haq, MOYNUL son of Akbar Ali, by executing a partnership deed dated 24/2007. No, that's not. Now, whatever I said, just, just before that, he submits that Moinul Haq, the number one partner in the partnership deed, expired on
25/8/2021.
25/8/2021. And in the partnership deed dated 20/04/2017, it was stated that the partnership made between Moinul Haq and the petitioner Moinal Haq, NAL, huh? NAL. Only difference is U and A. Moinal Haq was that the partnership would be at will, and that the first partner would be the key person and solely authorized by the partnership firm to perform all work in connection with the firm. First up, further, all charges from a bill of exchange, a promissory note, from a documents and papers relating to the business of the partnership firm and affairs of the partnership firm shall be signed, drawn, accepted, or endorsed by the first partner. That is the deceased Moinul Haq. The next para, the counsel for the respondent number 12 submits that on account of the power of attorney executed by the first partner in favor of the petitioner on 13/2/2020, the respondent number 12 completed the remaining portion of the contract work, and accordingly, the respondent authorities had issued the completion certificate and progress report showing that this contractor was the respondent number 12. Okay. He accordingly submits that the remaining contract bill for the construction work has to be paid to the respondent number 12, amounting to rupees
23,94,396.
23,94,39. Mr. R. Dhar, the learned counsel for the Tribal Affairs Department, submits, where is that? Submits that, there are many disputed questions of fact and that there is nothing to show that the writ petitioner is the rightful claimant for being given the balance amount for the balance work done, balance construction work done. Okay. Actually, before that, no, you just like before that, right? The counsel for the respondent number 12 further submit that as the respondent number 12 was not made a party in the writ petition, he had to have, the respondent number 12 had to implead himself, had himself impleaded in the writ petition on the basis of the order dated 16/9/2022 passed by this court in IA Civil 2769 of 2020. Then that, then Ms. Arda, okay. He submits that due to there being disputed questions of fact, the matter should be decided by a civil court as a recording of evidence is necessary. Next part. Mr. M. Hussain, learned counsel for the petitioner, submit that what did you say about the POA, power of attorney?
Regarding power of attorney, my lord, the power of attorney is shown to be executed on my lord
The power of attorney
13 February of 2020.
was shown to be executed on 13/2/22. Gustav, however,
However, my lord, the past partner submitted application on 8/11.
the first partner, Moinul Haq, had submitted a
Application for extension. on
application for
8/11.
extension of time
Yes, my lord.
for completion of the contract work on
8/11/2020
8/11/2020
and 8/4/2021.
and 8/4/2021.
So, my lord, Accordingly, my lord, the CR case is pending, my lord, against the, my lord, response number 12, my lord.
CR case, what is CR?
Yes, my lord, criminal case has been filed, my lord, against response number 12, my lord, alleging that, my lord, the
He further submits that a criminal case has been filed by the petitioner
Yes.
against the respondent number 12. When?
filed, my lord, in the 24, my lord, the date, my lord, 34/2020,
On 30/04/2024.
alleging that,
In the, in whose court?
for my lord, the alleging, my lord, the power of attorney is for.
Before whom did you file the case?
It was filed, my lord, before the judicial magistrate Gosaigaon.
Before the judicial magistrate Gosain stating that the power of attorney relied upon by the respondent number 12 was a fake document.
Correct.
He submits that the said case, the said criminal case is still pending. The said criminal case, that is CR number,
CR case number, my lord,
CR case number,
That
And-
is not registered. That the
31 of 2024.
31 of 2024 has, is still pending
It's still
before the said court.
Yes.
Is it pending or what?
Pending,
so let us dispose of that, directing to the concerned PS to investigate and register a case.
Has it been registered?
No, in my
No, my
instruction, there is no.
my lord, base on 33, transferred to JMFC for disposal, my lord, by order dated 4/4/2024. Base on 33.
So it is still pending. What?
Is still pending, my lord,
This is a fix for 2024.
or 6/4/2024.
Then what is that?
Thereafter, my lord, as per my instruction, it is pending, my lord.
So it said, so these are questions of fact which have to be decided. These are questions of fact.
And my lord, I have submitted on judgment, my lord, in paragraph 4 and 6, my lord. It is stated, my lord, the honorable Supreme Court stated, my lord, the power of attorney executed on behalf of a partner, my lord, is not bind upon the firm, my lord.
Okay, right. He further submit that a power of attorney executed by the first partner,
Yes.
which has been done in his personal capacity,
Yes,
does not bind the partnership firm.
yes.
That's all?
Yeah.
This you put it there. In it. Anybody else? Okay, right. I have heard the learned counsel for the party. The facts of the submissions made by the council show that there are disputed questions of. Further, the responding authorities have apparently reflected the name of the respondent number 12 as the person who had completed the contract work in terms of the completion certificate dated 23/2/2021 issued by the Executive Engineer PWD Kokrajhar Building Division. Showing the respondent number 12 as the power of attorney holder of the first partner, that is Moinul of the partnership firm, that is MS Moinul Enterprise. The progress report, that is annexed to the affidavit in opposition filed by the respondent number 12, issued by the Executive Engineer PWD Kokrajhar Building Division, also shows the name of the contractor of the said contract work to be the respondent number 12 as the power of attorney holder of MS Moinul Enterprise. Besides the question as to whether the first partner, Moinul Haq, would have issued a power of attorney to the respondent number 12. The further question remains as to who had constructed the remaining portion of the building. Building or buildings? Huh?
Two-story building.
Building, the remaining portion of the building. And as such, who should get the balance payment for the contract? All these questions, in the view of this court, require evidence to be reported. And as such, this court is of the view that the matter should be decided by a civil court. So for review of the reinstated law, the writ petition is dismissed due to there being disputed questions of fact. The above is subject to the condition. The above, however, gives the dismissal of however, liberty is given to the parties to approach the civil court for redressal of the grievance. The writ petition is accordingly disposed of. Outright. Yes, madam.
And item number 45, we have received the instruction. They are not, it's vague. We have repeatedly communicated with the department. But we are yet to receive a definite, at this time.
It will always be vague. Then it deliberately done, it appears.
So just pray for a further 2 weeks time to complete my instruction.
And if it's not done, then we'll call them. Okay, Miss M. Kalita, appearing for the PHE, submits that the instructions received by her are vague and she accordingly needs clarification of the same. She prays for 2 weeks' time to get the clarified instructions. This is a matter of it.
Like,
I wasn't safe.
highly okay.
So I'm paying for some economic.
Yes, any objection? No. Mr.
J. Burman.
A. Burman. Submit prays for adjournment on the ground that his senior, Mr.
J.K. Gupta.
Jacob Goswami is
For illness,
ill and unable to come to the court. The same is not objected to by Ms. Pida, learned counsel for the petition. Accordingly, leave this matter after 3 weeks. No one appears for the petition on call. It is noticed that no one had appeared for the petitioner on the last date also. In view of the above, it appears that the petitioner does not seem to be interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution.
This matter, your lord, it was, there are two matters. The first one, basically, we are here, because under the industrial dispute, order, there was a judgment of this, the award was initially passed. That was challenged by them.
Award by the tribunal.
Right.
To what effect?
Initially, she was, the person concerned, the employee was dismissed from service. Against that, now what has happened, the only issue will be, I'm just pointing it out for that after the dismissal, it was referred to before the tribunal, and then the award went in her favor, saying that she is reinstated with full back. In the, she challenged that award. She challenged, we did not. We wanted to improve. She challenged that award before the High Court for modification. The effect that the court should direct that she should be appointed as grade 1. She was not a grade 1. Appointed as grade 1. Then this honorable court, by the judgment, has dismissed him. She was called personally before the court and she was heard. After hearing, the court has found that there is no question cannot be, that it cannot be, so it was dismissed. But she was given one rider that if you can propose here another forum if you want to for enhancement of your wages. That was there. Now what has happened here? Here this case, after the award was passed long back, then the High Court judgment was passed. She did not come and join. We issued 2 letters initially that you come. As per the order, we are reinstating you, come and join in your service. She did not join. Twice she did not join. Then we have now issued another notice to her that we are not going to implement the award any further. On that basis, we have come. Then she said, no, I will only join if you give us grade 1. This is the last letter issue. We came before this honorable court saying that that cannot be done. And the award cannot be, your lordship, the validity of the award cannot go on forever. One thing happened, your lordship, with the back wages. If now she comes and joins, or maybe after 10 years, I have to give all the back wages without any.
Without work.
Yes. So therefore, we have come before this honorable court that this award has spent its course and so that there is the provision is there under the Industrial Dispute Act under section 19, 3 and 6, as well as the one rider there that once the period of award is passed, the period is for a period of 1 year, but it will continue until and unless notice by any of the parties is given not to finally implement the award. So this notice was given by us finally that we are not going to implement it. After that,
When was the notice given?
this was the third one.
When was
This
it
was
given?
given, your lordship, much later, because this was given in 23. 23 which month? 23 in the month of August 20. So after that, the law is that there has to be, after the notice, 2 months have to be. So that also elapsed. Now there is no question of implementation of that. Second part with regard to the enhancement of wages or it, that is a separate part. We are not on that. This is the other case that is there. There are 2 cases. The second case is on that part. That case we have filed challenging the application filed before the authority, the payment of wages of wherein they have asked for the enhancement of that wages. There was a long delay and an application for condonation of delay was filed. That was considered and we came before this honorable court. Earlier counsel was there. I came later on. So at that time, the court has considered the prayer of the petitioner and stayed the your lordship earlier the proceedings before the payment of wages tribunal holding it res judicata. And second is that the tribunal under the Payment of Wages Act does not have any authority to fix wages. If it has the authority, if somebody is not paid the wages or wages have not have been deducted, or if there is some dispute regarding that, that is the only issue that can be decided by the authority of payment. On the ground, that was. So these are the 2 cases in a nutshell. Now, your lordship, I'll take your lordship from the beginning. The first
So involving same person. No,
lordship. No, it's the same.
6698 of 23.
669823 is the first case that I have stated, that I'll rely on that first case, because that is with regard
No,
to
but
the
is it connected with this other one?
other one. It is somehow connected because the rider in the High Court has given them an option to approach the authority, and that is why I am going to, from this case itself, I'll show that already the tribunal has held that she is not the employee in grade 1. That has already been held. Now it has not been set aside by this one. That is why I'm taking up this case for. Your lordship will kindly put. I'll just.
So she has not joined. He or she?
She did not join till today.
But
She,
it's
it's a lady.
MD Manjarul.
No, that is the proprietor of the farm. Oh, this is a farm, proprietorship farm. It's
And
a
that Greenfield tea warehouse.
350. At that point of time, your lordship, it was filed by the proprietor by his name on Greenfield. Now it is by the Greenfield represented by the proprietor. Your lordship will kindly take up the page. I'm not going to go into the details with regard to the first incident, which is with regard to your lordship, the notices issued for your lordship, so-called notice and all that already has been decided by the court. We have nothing to do with that. I'll take your lordship from page 22. Page 20. Of the writ. First. Page 22, your lordship. This was filed on 29th of October 2010. This is the type copy. The original is at page 22C. Here your
This is an application.
lordship.
This is an application.
This is an application. This application filed before the authority appointed under the Payment of Wages Act. I'm coming to this because this was the initiation of everything. Page 22. Here, your lordship, the application was filed under section 3 of subsection. This is important. That is why I'm pointing it out. This is specifically subsection 3 of section 15 of the Act. And this application was filed for complying the provisions of section 3(1)(b) and 5(1)(b) of the Payment of Wages.
Section 3.
3(1)(b) and 5(1)(b). This was filed under section 15 for compliance of these two sections. I'll come to that later, your lordship. I'm not going to take this. What has happened in this case? They filed an application. Then, your lordship, what they have done? After filing of the application, they have withdrawn the application. They have withdrawn the application with a rider that they would go before the labor under the Industrial Dispute Act, not the Payment of Wages. There is an order to that. Just bring, I'll just point out the order, that order. Just a minute. Right, that order is in the other case. And I'll point it out in the other case you mentioned. That order passed by that authority under the Payment of Wages Act is in the other. Here you're not seeing. I'll just point out the image.
In the other writ petition.
In the other writ petition, it has been annexed, your lordship. It is at page 31 of the writ petition. The order was 8/6/2011. I'll point out later. I'm just mentioning it.
No, but how is this issue has any relevance here? There's no relevance.
No,
there.
it has. That's why I'm pointing it.
has a little bit of relevance. That's why I'm putting it up. Though it is more concerned with the second case, but some relevance is it is page 31. This is the order. It is a typed order of the next page. It says the claimant files a petition with a prayer to entertain the matter under Industrial Dispute Act 1948, which the petitioner originally filed for the same before the Extended Labor Commissioner Guwahati, but the concerned ally who filed the claim petition after several days of employee come joint discussion before the authority under the Payment of Wages Act. It appears from the contention of the WS filed by the OP, the case was dismissal case against the petitioner. And the petitioner instead has no scope to entertain. This was the A scope, it should be no scope to entertain under the Payment of Wages Act, and the concerned petitioner may move before the appropriate form under the Industrial Dispute Act 1947. So now, Your Lordship, she moved the industry. I'm just pointing out that only that order. We are not concerned with further. Now, Your Lordship will kindly take up the main the other case. So it is also annexed here. I'm sorry. Page 33 of this petition, I have annexed this. This petition, it's also annexed, page 30. Now, after that, Your Lordship, the case was moved before the labor court. There is a reference before the conciliation page, went for a reference under section 10 of the Industrial Dispute. After the reference, the award was passed. The award, Your Lordship, will find at page 30. I have to read some portion of the award for convenience of Your Lordship. Page 35, the award starts. This award was passed on 33,013. Here, Your Lordship, I'll just take Your Lordship to page 36, para 3. This is for a overall, Your Lordship, the knowledge about what is the facts of the matter. Para 3, page 36, Your Lordship has got it. Page 36. The case of the workman side as revealed from its written statement is as under. The management of Greenfield Tea Warehouse, Panjawari, Guwahati, employed Srimati so-and-so orally, as its employed to maintain its account with effect from so-and-so. The management used to pay her rupees 1,000 per month as wage during the period from November 1996 to December 1999. Thereafter, her wage was increased and she received rupees 2,000 per month, 3,000 per month, and 4,000 per month during the period from January 2002 to December 2002. So January 2003 to December 2007 and January 2008 to April 2010 respectively. In 2005, the management purchased a computer and the workman was ordered to work in the computer and to maintain all its accounts by recording the computer. On 7/4/2010, the workman orally requested the management to issue a written appointment letter to her and to pay her monthly wages according to the pay scale settled by the agreement between Guwahati Warehouse Association and All Assam Warehouse Workers Association. Thereafter, by letter dated so-and-so, the management made some allegations against her, stating that she had been working in the computer section without authority and that it found some anomaly and irregularities in her work done in that section. By virtue of the so-called notice dated so-and-so, the management alleged that it was that found shortage of 2 bags of tea in the stock and she was restrained from performing her duties in the warehouse with effect from so-and-so until a final decision was taken by the management. Thus, with effect from 2010, the workman did not have any work and so also she did not receive any pay since months of May 2010. On 3/5/2010, the workman sent a reply to so-called by register post. By virtue of the order dated so-and-so, the management discharged the workman from her service without mentioning any date from which the discharge order would come into effect. The workman joined her service as a grade 1 employee and she held a post just below the post of in charge. In absence of in charge, she also used to perform her duties. Since the inception of her service, the management used to pay her lesser amount than that of the monthly wages. Thus, she is entitled to an addition of so-and-so for the work done by her till the date of her discharge from service and a statement in respect of the amount in annexed with the petition. And the prayer is to pass an award directing the management to reinstate her in in service with back wages to disburse an amount of so and so as wages due to her on account of less amount of monthly wages paid to her during the period of her past service, to pay cost of her proceeding and to grant any other relief as the court deemed fit. So this was her allegation, her application, her WS before the labor court. Now, your lordship, what has happened? We have filed our WS. In our WS, we have taken all these into consideration. And then your lordship will kindly see page 40. It's the decisions and the evidence of the court. I'm not reading all the facts and figures here, not required. For just decision, I'm just pointing out. Page 40. Yes. Para 8. This is her own evidence. In her evidence, the workman PW1 has claimed that after being appointed on so and so, at first she was asked by the management to maintain its account. Then after acquiring a computer in 2005, the management asked her to maintain the account and the computer. And finally, she was transferred to the goods and receiving and delivery section. During cross-examination, she admits that she does not have any certificate or diploma for operating computer, and that in the computer system of the management, there was no system to maintain accounts. So, in my considered view, this is the view of the labor court, her claim that she was entrusted by the management to operate the computer and to maintain the accounts of the management in that computer cannot be relied upon. She further says that she was directed to perform as in charge of the warehouse in absence of the in charge. She proves exhibit so-and-so as her identity card. Exhibit so-and-so is the signature of Manirul Hassan, one of the partners of the firm. On perusal, it is seen that she was designated as a clerk in her said identity card. She further says that she was paid wages at the rate of ₹1,000 per month at the time of her joining, and the management has gradually increased, and finally she was paid an amount of ₹4,000 per month from so and so till the date of her termination of service. And your lordship, now I will go to para 9. From the above discussion, it is seen that while the workman was designated as a clerk in her identity issued by the management, the main function of the workman, despite her claim that she was directed to perform as in charge in the where in absence of in charge, was that of a clerk. There is nothing in evidence to record to show that she was employed in any supervisory capacity or that her functions were mainly of managerial nature. In view of above, though undisputedly she was paid wages at the rate of 4,000 per month at the time of her removal of her service, the workman must be held to be a workman and wages under section 2S of the IPA. So two things comes here, your lordship. Number one, she is a workman who is not in the managerial or supervisory category. She is a clerk. Secondly, she was at that point of time during the time of her divorce or court. These two things actually I tried to point out. Now, your lordship, I will not go into all this. Page 44, para 13. Para 13, just 2 lines. In view of the above, I find para 13, page 44. Page 44. In view of the above, I find and hold that the management did not help any valid domestic inquiry before terminating the service of the body. So the court found will continue. Then your lordship, up to paragraph 13, come to the paragraph for page 46. Page 46, paragraph. Sorry, page 45, para 16. Page 45, para 16. So the findings of the tribunal, para 16, in view of the discussion made above, and the considered opinion, the management has failed to establish the charge level against our workmen on merit also. Consequently, find that the management of so and so is not justified in dismissing or discharging the workmen so and so from service. The issue is decided accordingly. Now, your lordship, page 46, para.
So why was the service terminated?
See, that I read, your lordship, what has happened while she was working. This is a tea warehouse. So there were, while she was supplying the tea, she was in looking after the supply of tea bags.
Also, 2 bags were missing.
2 bags were found missing. So she was, earlier also there was some issue. She was, initially also she was said, warned, but again this happened and ultimately. Anyway, that part we are not concerned. We have accepted the order of the sound of the tribunal and then we issued letters to her that you come and join. She did. That's what. And then, your lordship, the part with regard to the entitlement of relief, that is at page 46. Page 46, para 18, penultimate paragraph. In view of above, I find and hold that the concerned workman is entitled to full back wages. In her WS, the evidence, the concerned workman has claimed that the management had paid her less amount than she was entitled to, and so she has claimed an amount on that count. However, in my considered view, the said claim of the concerned workman is a matter to be considered by a separate forum under separate section of law, and hence this court is unable to grant her any relief on that. So, your lordship, reinstatement with full back pay. And the back wages, your lordship, was found to be 4,000 at the time of dismissal. So now what has happened, your lordship? Thereafter, your lordship will find the next page, page 48. The first letter was issued. I'm not reading the letter. This was issued that you were ever asked to join your earlier post of receiving and delivery clerk with all earlier oral terms and conditions within 15 days. This was given first, page 49. About, your lordship, after about 1 year again, we have issued another letter, 25/8/2014, again requesting her to join, or it will be held to be abandonment of service. Anyway, this was otherwise noticed, but thereafter actually she came before this honorable court by filing a writ petition. And the judgment of this honorable court at page 50. The facts remain the same. I will not read again. Here, I will just read the part which is not there in the award. That is at page 54, your lordship. This is the observation of the court. For para 14, submissions made by the learned counsel for the parties have been considered. Page 54. Para 59. Considering that the writ petition has been filed by the workman, even though the award is in favor of the workman, court thought it fit to interact with the petitioner in person. Accordingly, the petitioner appeared before the court on so and so and explained the circumstances leading to filing of the present writ petition, which have been mentioned in the order dated 15/7/2015. This is, she personally appeared in the court, and court asked her, so it was a different counsel was present at that point of time. In the affidavit, it is been, court asked her that this cannot be done because you have come from modification of the award, which is a separate issue that cannot be done in this case. She was called for to accept the award and join, but she refused. That is what is there in the affidavit. Then your lordship will find.
Where does it say that?
That
She
is
was
not-
asked to join. Where does it say that she was asked to join?
No, the court has asked that. I cannot.
It's not recorded.
Not recorded. I don't know whether it was recorded in the order at 15/7/2015 in the writ petition. I am not sure yet. So
Then your lordship, I'll just read the final page 61, the decision of this honorable. Para 26. I'm not reading the judgments and other effort by the court, your lordship. It was the practically the part. For the all the page para 26, for all the aforesaid reasons, relief sought for by the petitioner cannot be acceded to. Accordingly, writ petition is dismissed. So upholding the order of the tribunal. Only the rider here is that para 27. However, dismissal of the writ petition will not come in the way of enforcing the award dated 30/3/2013 and grant of relief to the petitioner in terms of the said award. If the petitioner has any further grievance as noticed in the award dated so and so, it will be open to her to raise such grievance before the appropriate forum in accordance. So what has happened, your lordship? After that, she approached again back to the Authority of Payment of Wages Act. She again went back to the Payment of Wages Act by filing an application for which the modification was not done yet. She wanted that she should be granted the amount of so and so, which comes to about calculating her calculations come to about 10 lakhs.
On what ground that it should be
No,
That's
since the she is appointed in grade 1, and so she's entitled to the salary of
but
grade.
when is the appointment order?
There was no appointment order. It was that the order I have read, your lordship, the recorded by the award in the award, the tribunal recorded. She was given an oral, your lordship, appointment. It was a contractual appointment, and she was given initially salary 1,000. That is, she herself admitted 1,000, 2,000, 3,000, and went up to 4,000 at the time of her termination. So, since it was a contractual appointment and the termination was done, therefore there was some lapse in the part of the authority of the I think firm in not holding a correct inquiry. That is why she was reinstated. The firm was fine that you are reinstated, fine, come and join in your earlier post in earlier country. She says no, I will join only in grade 1, and she did not. This is the reason. Then she approached the Payment of Wages Act, saying that I should be granted the amount of grade 1, and that then again file an application. But there was a delay, so she filed a condonation of delay petition. The condonation of delay was allowed by the authority. Against that order, the second writ petition. I'll come to that later. Now, this part, your lordship. Next, this part here, your lordship will kindly take up page 68. After everything, your lordship, in page 68, this is on 18th of August 23, we have issued a notice that award dated so and so has after several years have left since then. So you are no longer eligible to enforce the award dated so and so passed by the labor court on so and so as the award has been. This is for your information. So this notice, your lordship, was as per section 19. The lordship will kindly take up the Industrial Disputes Act. Industrial Dispute Act, section 19, 19(3), lordship 3.
Yes.
An award shall, subject to the provisions of the section, remain in operation for a period of 1 year from the date on which the award becomes enforceable under section 17A. 17A says that the award will be enforceable after it is published. So I'll not read that. Then your lordship will kindly go to 6, 19(6). Notwithstanding the expiry of the period of operation under subsection 3, the award shall continue to be binding on the parties until a period of 2 months has elapsed from the date on which notice is given by any party bound by the award to the other party or parties intimating its intention to terminate it. So, your lordship, so award continues. So, in fact, it continued, even though it was more than 1 year, it continued. Then the terminating notice was given on August 2023. So, in October 2023, the award is done. Now, she filed a second again, your lordship. Then, after that, page 69. She filed one application, your lordship, a reply to the termination. I'll read that. I am in receipt of your letter issued by so and so, so and so, so and so. Reference above. At the very outset, I have to say that the said letter is itself a shock to me, not only because it was issued to me when the subject matter involved is in the sub judice before the Honorable Guwahati High Court, but also due to the reason that the letter contains some concocted facts and circumstances. To be precise, you have mentioned in the above record letter that two letters were issued to me on 19/8/2013 and 25/8/2014 in compliance with the award pass in reference case number so and so, and thereby requested me to rejoin in the post which I have held before my termination. In regard to these two letters, I admitted receiving the first letter, that is 19/8/2013, and accordingly I had responded to it by my reply on 2/9/2013, which itself is self-explanatory, but I vehemently denied receiving the second letter dated so and so, and therefore the question of any response from my end doesn't arise at all. That I was anticipating a positive response from your end to my reply dated so and so, but unfortunately on receipt of the above written letters, it appears to me that now you would somehow want to deprive me of my legitimate claim, which I am entitled to receive from the management of your esteemed office. Having said so, I hope and trust that you would be kind enough to give me an opportunity to me providing legitimate pay scale of senior grade 1 employee, and I am ready to comply with the same. And that cannot be done, your lordship, because this is not the, and I have filed one additional affidavit.
No, right.
That additional affidavit, she has, her initial letter I have annexed. Her initial reply to my letter, that is 2013, that I have annexed. At page 74. This is, it was issued to us. Having regard to your effort, letter effort, which I received on so and so, it is stated that you have not reinstated me in my previous service of senior grade scale 1 with scale of pay of so and so per month, which was due from month of May 2010 when I was dismissed from service. Moreover, an execution proceeding of award is pending, and on the other hand, you have asked me to join in a lower grade of service without mentioning my pay scale. On such disputed situation, I am unable to comply with the request. I request you to make an appropriate order reinstating me in my previous service of senior grade 1 with appropriate. So she made the same thing that she wanted to be appointed in senior grade 1 and salary should be given 17,000 with this with the award, and this honorable court has rejected. Therefore, now your lordship, after the issue of the notice for termination, the award is deemed to have been terminated. That is basically the first. The first case, and here you go, basically this. And in this regard, I'll just
October 2023 then. October 2023,
October 20,
the, the,
because,
the,
2 months, and that judgment's also there.
the award,
that-
award loses its force.
No, it has to, your lordship. So I'm just pointing, giving, providing your lordship 3 judgments, short judgments, just a few paragraphs from there. I'll just show the paragraph there. If any comes up there. Same thing. Court has held that after the first one is a very old judgment which has been followed subsequently in the other 2 cases. Which the citations are given in the top. I'll just refer your lordship to page 5. Page is put down. Paragraphs are not there.
Yes, sir.
Page 5, down below your lordship will see page 5 and the second paragraph. Here I am just reading it. This makes it clear. This makes it clear that after the period of operation of an award has expired, the award does not cease to be effective, for it continues to be binding thereafter on the parties until notice has been given by one of the parties of the intention to terminate it, and 2 months have elapsed from the date of such. So it had been made clear by the court that this is the normal rule. Then you'll also the second judgment, that is with regard to the case of West Bengal, Karnani Properties versus this is of 1909 subsequently. Here your lordship will kindly go to page 8. The same thing, one line I will show. Page 8, down below your lord. I just marked a small marking. In our opinion, this contention does not require consideration in view of the finding recorded by the learned judges of the division bench of the High Court that the letter dated so and so was a notice under section 19(6) as well as under 19(2) of the Act. It has been found that the said letter of the union which was addressed to the legal was sent to the appellant company, and that in the said letter there is a clear the intimation of the intention of the employees to terminate the award. And from the letter, the appellant dated so and so, it appears that the appellant has become aware of the intention of the union to terminate the award and the order of reference made on so and so after long expiry of the period of 2 months. It is not the requirement of section 19(2) of the Act that there should be a formal notice terminating a settlement, and notice can be inferred from the correspondence between the parties. Here, it is a correspondence is there, but it is a termination notice. Intention has to be given to the parties, which has been. And the final one, your lordship, a small judgment of 2002 Bank of India versus presiding officer. Here, paragraph 5. Here, the court has not given any specific. It has referred to the earlier first judgment that I have referred. In this in para 5, in that decision, except to make a statement of fact, the question whether these two awards were in force or not, and was not in issue at all. Therefore, no question of any pronouncement at this point is necessary. This aspect of the matter has been examined in detail in the case of South Indian Bank versus A.R. Thakur, the first judgment that I have seen. So, the first judgment has been followed till date. That's all. In the first case. Second file, the facts. In this case, also the facts are absolutely the same. Here, the matter starts from the second part, your lordship, from the time when they filed the application before the payment of wages authority for enhancement of her.
For enhancement of their wages.
It's for enhancement of her wages on the ground that she has to be given the payment of wages of a senior grade 1. And that is some calculations made 17,000 from where we don't. So that is, here we have taken a specific all the same orders are, your lordship, specifically in this case also. Here your lordship will find at page 61. Page 61. I'm going subsequent there to what we came in the earlier case. Here your lordship.
So out there that wages were dismissed. The case was dismissed.
My case will be, your lordship. The second case will also be based on the facts and circumstances and the decision of the award as well as this on the in the first. What has happened? The first case, it has been very clear that you are 44,000. You're a clerk. You're not a grade 1 officer. And second point, which the point here we will come to, in the Payment of Wages Act, which at the beginning I have referred to your lordship that under section 15, they want compliance of section 3 and 5, 3(1)(b), 5(1)(b). Lordship will kindly take up the Payment of Wages Act. 3(1)(b) and 5(1)(b).
Payment of wages.
3(1)(b) and 5(1)(b) does not say anything with regard to calculation or fixing wage. In the Payment of Wages Act itself has said only one thing, that if somebody is not paid her wage, his or her wages, or there is a delay or the term of the wages, then only the Payment of Wages Act come into force. It cannot fix the wage. That is what there. And section 3(1) and 5(1), both your lordship does not say anything. Your lordship will kindly see. 3. This is a responsibility for payment of wages. Employer shall be responsible for payment of person employed by him of all wages required to be paid under the Act, provided that in the case of person employed otherwise than by a contractor, B will be in industrial or other surveillance if there is a person responsible to the employer for the supervision and control of the industrial or other stuff. This does not work because she is not a supervisor here, number 1. Then comes 5. Time of payment of wages. This is not a case for time of payment of wages. This is a case for enhancement or giving her a different wage which she has been getting you. The wages of every person employed upon or in B, any other railway factory or industrial or other establishment shall be paid before the expiry of the tender. So where is your lordship this comes with these two? Therefore, your lordship, the second case also does not fall under this category. And section 50,
So this has been filed by you.
both are filed by us. Section 15, your lordship.
Yes.
That is the last one, because the claim was filed under section 15. Claim arising out of deductions from wages or delay in payment of wages and penalty for malicious or vexatious claims. So the whole application under section 15 before the payment of wage authority was filed under section 15. For what, your lordship? Section 15 specifies claims arising out of deduction of wages. There is no deduction, your lord. Secondly, delay in payment of wages. There is no delay in payment of wages. And penalty for malicious or vexatious. There's no such. She has also not claimed malicious and vexatious. One more submission I'll make here, lordship, for a moment. While she was in service, your lordship, and receiving the pay, she never raised it at all. She never raised the issue at all that I should be granted senior grade, I should be granted senior grade pay scale. That was never. Once she was found, caught, and then this
It
procedure
has been raised only after the award.
that is just before the award. When
For the award.
yes, but when the issue was referred to in the reference, then this is basically my approach. Therefore, your lordship, the claim in the application before the payment of wages act, the proceeding with it needs to be interpreted. It's fine. What has to be interpreted? The proceeding before the payment of wages. Authority under the payment.
The
Where
proceeding,
they have filed the application now.
that is still pending.
Still pending by
It is pending. This is stayed by the Supreme Court. The stay order is annexed in my affidavit filed in the IA. They have not filed any affidavit. In the IA, I have filed the affidavit in reply, where I have
Yes,
annexed.
okay.
The court also in the order, I'm just referring with the order, court also specifically said that it cannot be while staying this. That order is 28/2/2018. IA number aslet 2451. 2451. In the IA, I have annexed in my affidavit.
Where are the courts here?
What court took two grounds here, your lordship. First, I'll just read that short order. The present matter relates to the claim for higher salary under the payment of wages raised by Swen.
No, order dated
Order dated 28/2/2018.
28/2.
I have annexed that in my affidavit.
Passed in IA number?
Passed in, this was not passed in IA. I think this was passed in WPC 1094/2018. The main case. In the main case, it is passed. And I have annexed it in my affidavit.
1094.
In my case at hand, your
Page?
no case at hand.
Case
your
is
lordship,
there.
This order was
Acha.
28/2/2018. Order you must find in the order. At the initial stage, order 6 from 19. At the 28. Lordship has got 28. At present, the matter relates to the claim for higher salary and the payment of wages act Swenson, as raised by Swenson, who served as delivery clerk with field warehouse. The partnership concerned where the partner is the partner. The respondent number 3 was dismissed from service on Swenson, and at that stage, the Assistant Labor Commissioner entered in the application of the employee for higher salary and the Swenson notice dated Swenson. But this process was not finalized. Thereafter, reference was made on dismissal of the employee under the award dated so and so in the reference case number so and so. The learned labor court Guwahati ordered reinstatement of the employee with full back. The employer accepted the award and issued a letter to the employee for a reinstatement under the award dated so and so. But claiming higher salary upon reinstatement, the employee filed WPC so and so before this court. The learned single judge under his judgment dated so and so declared that the petitioner is disentitled to any relief, but permitted her to seek enforcement of the award dated so and so. It was also left open to the litigant to raise other grievances before the appropriate forum in accordance with. In pursuant to the above observation, the High Court, the respondent number 3 had again reapproached the authority under the section 1 under the 1936 Act to secure higher salary.
Anyway, the petitioner had approached in the, before the tribunal, it had brought up the issue.
The petitioner as a employer opposed the application of ground of res judicata and delay. But the Assistant Labor Commissioner under impugn order has condoned the delay and directed the employer to file it. So-and-so council relies on the Supreme Court judgment of so-and-so to contend that authority under the 1936 Act has no jurisdiction to determine the question of potential. This is what I refer. The senior counsel submits that when the earlier process initiated to the said notice that it was abandoned, the second process under LPWSO is legally barred in view of what in a lack notice and in the meantime proceeding has been stayed. So the proceeding remains states since then. And now, Your Lordship, my prayer is that it is the proceeding itself is illegal. It is beyond the authority of, therefore, it has to be. That's my answer.
My lord, actually, my friend has come after 3 cases already been finished. Initially, the case was filed in the year 2012 before the labor court by reference case number 2 of 2012. And
Reference case number 2 of
reference
2012.
number 2 of 2012.
That was disposed of on
Disposed of my lord 30 2013
13/3/30.
201. And award by parts of this award has been given. My lord, your lordship has gone to my friend and petition. So, my lord, application number, the LPW number 16 of 2015. Has it come along with the report? The report has been called for. Main case which is pending before the court below, that is the LCR.
So how does it matter?
Oh, my lord, this record matter.
No, what is the issue? Why is the report?
Issue is that this case is pending before the court. And that is LPW number 16 of 2000 before the labor court.
LPW
16 of 2015.
with regard to the higher pay.
Yes, wages. Back wages, with regard to the back wages of the employee.
Okay, that is pending to what?
That case is pending, yeah. And the proceeding of this case pending proceeding has been stayed by the honorable, by this honorable. And that, for that, thereafter my friend has filed another case. One case is pending, thereafter my friend has another case. Issue almost same. That my humble prayer before your lordship, that the whole cases may be sent back to the court below. It is labor commissioner. If the case is pending there, and he will go to the record and he will pass the report as part of that. But one thing pending, only simple query before your lord.
No, it is. There is one issue. The first issue is with regard to your reinstatement. Correct. Now the reinstatement issue is not before the Labor Commission. You can't hear me or what? Huh? Whatever, sir. Now the issue regarding your reinstatement, that is not before the Labor Commissioner.
My question is the question, my award has not been given.
Huh?
My award, the order has been passed on 33/2020 is not implemented yet.
Correct.
My
Now
award
you see.
has not been given.
Correct. Now, no, please understand one thing. As per section 19, they have issued you a notice to act upon the award. and rejoin your post. Now you have not done it. 2 months have gone by. The award was passed in 2013. You have deliberately and not joined the post, saying that you should be given the pay of grade 1. Now, there is nowhere stated in the award that you shall be given the pay of grade 1. And this court also, in the earlier round, had decided not to go into the issue. So that the question of whether you are entitled to grade 1 is not an issue before this court.
That's an issue, my lord, because
No, it cannot be.
I know my saying is, I have gone to the lower court below by virtue of this honorable court order. Honorable Justice Jol Vishya, in the writ petition number below, in the writ petition number, my friend has next.
Yes, to go to the appropriate forum, correct?
But to go to the appropriate.
Now, what is the appropriate forum you have gone to?
Appropriate forum, labor court.
Labor court.
Assistant
And
labor court.
the earlier award passed by the award reinstating you was passed by whom?
By labor.
By the labor court. And the labor court earlier,
Yes.
what did it say? That it cannot go into that issue.
Labor court.
Let us see the award.
The authority to pay my,
Let us see. Let us see the award of 2013. Where is the award of 2013?
My lord,
Yeah, award of 2013.
award of 2013, my lord, last operative person, my lord, last paragraph, kindly have a look at. My lord. Number 19, paragraph 19, raised in my petition. That is, from the above, it is found and held that the management of Greenfield Tea Warehouse is not justified in discharging workman Srimati Rehana Begum from her service, and that she is entitled to be reinstated in her service with full back wages.
Now you
Clear order, my lord.
correct. Now, unfortunately, you have not read para 18. Please read para 18. You are reading only para 19. You have got no, please, huh? Para 19 of the same judgment. You have read para 19. Please read para 18. What is para 18? Come to para 18. The sub para of para 18. In view of the above.
In view of the above, in their evidence adduced from the.
No, below that.
In view of the above, I find and hold that the concerned workman is entitled to full pay wages. In her WS and evidence, the concerned workman has claimed that the management paid her less amount than she was entitled to, and she has claimed an amount on that account. However, in my considered view, the said claim of the concerned workman is a matter to be considered by a separate forum under separate section of law, and hence the court is unable to grant her any relief on that count.
So, when the labor court in 2013 has said that the issue raised by you regarding your higher pay has to be considered by a separate forum, can the same labor court in your other case filed in 2015 take a different view?
So, my lord, actually here in all those cases, this order has not been challenged. This might
Correct. That is why that is against you. That is exactly you're shooting yourself in the foot. That is correct. This order has not been challenged, and that is why how can you now claim your higher pay in the same forum which refused to entertain your pay? That is exactly my point, and that is exactly what you have just stated. This order has not been challenged.
That order has not.
This order, but it was challenged in the Supreme, in this court, and this court refused to interfere with this order. Now, how can you go back to the same forum?
Oh, my lord, the question is this in this order. One thing has not been mentioned, regarding my senior scale of thing. The order has not been met. So I came before this honorable court by filing the writ petition. And that order has been, and an order has been passed by Honorable Justice Golvi. Send back the matter to the, dismissing the petition. But however,
Dismissing your petition.
my, however, directing it is the one, Rehna Begum, the employee, to go to the appropriate forum
Correct,
and to raise her question of
correct,
even,
correct.
and so that, my lord, this LPW 2016 spending
No, now you see,
that I have filed here.
you see, what has happened, the labor court has said, it is not going to decide your claim for higher pay. And you should go to the appropriate forum. Agreed with that, you went to Justice Ujjal Bhuyan. Justice Ujjal Bhuyan upheld the labor court decision. Now, in violation of the judgment passed by Justice Ujjal Bhuyan, you have gone to the same forum. How can it? It's like this. He is the judge. Your claim for higher pay is before him. He says, I cannot decide this issue. You please go to the appropriate forum. Now, you come to me challenging his order, and I uphold his order. Now, what do you do? Instead of going to the appropriate forum, you go back to him.
My lord.
That is what is happening.
No, my
I think
point
that's
is this,
correct,
my lord.
Mr. Manan. That is
My
the issue.
case is pending. There,
Correct.
I am giving
That's
some
the
time.
issue.
And my lord, immediately, they have filed a writ petition. That is, the proprietor has a file petition. Proprietor has a file petition by WPC 1094/2018. WBC number, second case, today's list, second case.
Yes, yes.
And my lord, against this proceeding, which is pending before the court below.
Correct.
And Honorable Justice Rishikesh Roy, by order dated 28/2/2018, passed an order without calling for the record. Simply, he told that in the meantime, further proceeding in that LPW number 16/2015 before the Assistant Labor Commissioner State until the returnability notice. That proceeding has been stayed.
Correct.
That proceeding has been stayed.
Correct.
So now we are undone, my lord. We cannot move here in the
Correct. Now, that is why this court has to decide whether the stay order was correct or stay order is correct. What is wrong?
But record has not been called for.
No need. This is not a disputed question of fact. You are admitting yourself that it is before the labor court. What is there to what disputed question of
Now,
fact?
my lord, my only fear before your lordship, my landed card annex, the last page, my lord, in WPC number 6698/2023. Last page, my landed card annex I have seen. For what reason I am not going to join, and what is the position, my lord? Page 69, my landed card, page 69. My lord, reply to your letter dated here, sent letter, I gave you reply. Sir, I am in receipt of the letter issued by you by letter under reference above at the very outset. I have to say that the said letter in itself shocked me, not only because it was issued to me when the subject matter, even it is subjugated before the Honorable Guwahati High Court, but also due to the reason that the letter contains some concocted facts and circumstances. To be precise, you have mentioned in the above referred letter that 2 letters were issued to me on 19/8/2023 and 25/8/2024. In compliance with the award passed to reference case number 2 of 2012, and thereby requested me to join in the post which I held before my termination. In regard to these 2 letters, I admitted receiving the first letter, that is 19/8/2013, and accordingly I had responded to it by my reply dated 2/9/2013, which itself is self-explanatory. But I vehemently denied receiving the second letter dated 25/8/2014, and therefore the question of any reason response from my end does not arise at all. That I was anticipating a positive response from your end to my reply letter dated 2/9/2013, but unfortunately, on receipt of the above referred letter, it appears to me that now you would somehow want to derive me from my legitimate claims, which I am entitled to receive from the management of your esteemed office. Having said so, I still hope and trust that you would be kind enough to give an opportunity to me providing legitimate pay scale of senior grade one employee, and I am ready to comply with the same and henceforth, and for which active kindness I should want to do. That reply I have given. That reply I have given, my lord, on 29/8/2023.
Correct.
23.
Correct.
And this is pending.
Mr. Counsel, please understand the law. Section 19 of the Industrial Disputes Act
Section 19 of it.
clearly provides that 2 months within, if you do not join within 2 months, if the award is not implemented, then it basically loses its force. And you have been given notice of that fact by the petitioner. Now, despite the award nowhere stating that you should be given the pay scale of senior grade one, you are still demanding the same. Now, on what basis you are demanding, we do not know, because no court, no tribunal has awarded you that senior grade one pay scale. You came to this court, denied. You went to the labor court, denied. Labor commissioner. Now again, you have gone to the same labor commissioner, which has been denied earlier and which had been upheld by this court. Where is your case?
Actually, this period, I was appointed on 14/11/1996. I will kindly get the matter. I was appointed on 14/11/1996. And I was terminated on 25.
You see, Mr. Counsel,
After rendering
you see,
prolonged for 10 years.
Mr. Counsel, when the learned single judge, Justice Ujjwal Bhuya, at that time, has not agreed to your prayer, when this court has held that this matter cannot be decided here, but you have got to go to the appropriate authority. And this court had upheld the Labor Commissioner's decision that it has to go to the appropriate authority and that it cannot be decided by the Labor Court or by this court. We are still going to the Labor Court again. How? It's like he says that I cannot do it, but you're still going to him. Please do it. How can it be? Res judicata is there. It is already decided.
I cannot expect, my lord. They were calling for the LCR.
LCR is also-
Whether the order can the final order.
Why not? Why not? This is not a question of,
Without
there is no question of dispute on fact. This is a question of law. There is nothing, no dispute on fact. There is no dispute on fact. All the facts, what you are saying is admitted. We admit your fact. It's only a question of law.
My lord, the back which is, my lord, what payment I have not been received
You have not
during
joined.
my service period. That should be paid, my lord.
You have not joined. You do not want to join.
During my period of work also, the payment.
You do not want to join. What to do?
No, my lord, during my work period.
I think, you see, maybe.
Salary for the rendering service, my lord, period of rendering service. That should be paid, my lord, at least. I mean, one is letting my lord, only that is not correct.
He has specifically in the award itself is for from April it has not been paid. She was terminated from, she's not been paid. from
April which month?
In 2010.
April 2010.
2010, she was not. That is admitted and it is there in the record.
He
And
has,
now, where is the question of, well, I was working, I was not, she was not working from there. Reinstatement, you come and join, immediately you'll get back the salary. After that, if you have any objection, no, kindly raise our pay, something could have been done. Rather than, then I think it would have been a different, that issue would have been different, that for a raise of pay or some extra pay scale or something, she could have raised a dispute, it would have gone on a different. That was not done. That's basically what she wanted to take
eating,
the money without doing
having
anything.
your cake and eating it too. By the ball. Now this issue.
My question is this, my lord, the president of the employee is sitting here, he is an executive. I'm just asking him whether she has received the working floor salary or not. He's denying, no.
Naturally, she's denying because the law requires that you should be reinstated. The law requires that you should join your service. You have not joined. If you have joined,
My palm will say that if she rendered the service period of working of service period. that
you have
working
been,
period
you have
should be
been,
paid.
you have been given your pay, you have been given your relief as per law. So he has filed his writ petition as per law. Now, for doing complete justice. Supreme Court is the only, under 142, it can do complete justice. I do not have that power.
My only says that, my lord, since a case is pending before the level commission, if all the matters be sent before that court.
There's nothing, no.
The matter will proceed.
When this court has already upheld the Labour Commissioner's earlier order, that the Labour Commissioner cannot decide the issue of your wages. How can you go back to the same court? When your issue has been raised to the earlier Labour Commissioner. Labour Commissioner said, go to the appropriate forum. You came to this court upheld the Labour Commissioner's order. Now you have, despite the order of this court and the Labour Commissioner's order, you have again gone to the Labour Commission. Just because now a different person is sitting doesn't change the fact that it is still at the Labour Court. Just because I am sitting today here as a High Court judge does not mean that another judge who sits here after me can take a different view unless there is an appeal.
My point is, I am not going to file a fresh case here. Case is pending here, my lord. So I think since the matter is substituted there, without pulling for the record of that court, without going through it, how the validity of the order of
Let me
my lord, my lord, in this that I have collected some judgment and
You can give me in the meantime. Wait, I will stop the debate. Yes, heard Mr. Y.S. Mana, Learned Counsel for the petition.
case is pending there, my lord.
Also heard Mr. H.R. Khan, Learned Counsel for the respondent number 3. Mr. S.R. Barwa, appears for respondent number 1. That is the way for the petitioner in both the requests. Also heard Mr. So H.R. Khan for the respondent number 2 in WPC. Which is the same thing. Is it the same? No. Respondent number 2 in WPC 6698 of 2023. And respondent number 3 in WPC 1094 of 2000. Also heard Mr. S.R. Barwa, learned government advocate for the state of Assam in both the reports. Next paragraph. At the outset, it may be stated that the petitioner in 1094 of 2018 is the proprietor of the petitioner firm in WPC 6698 of 23. So further, the respondent number 2 and respondent number 2 in 6698 of 2020 is the same person as respondent number 3 in WPC 1094 of 2008. The parties have reflected in WPC 6698 of 2020 are being, what is the word that we use that the party's position in this petition is being used while deciding the matter? What do I say? The parties as reflected in WPC 6698 of 2020 are being
Employer and employee.
no. Are being
Employer and employee, my lord.
are being. used for disposing of both the writ petition. As the subject matter in issue in both the writ petition are connected to each other. The writ petitioner is the writ petitioner, and the writ petitioner is the employer, while the respondent number 2 in 6698 of 2023 and respondent number 3 in 1094 of 2018 are the employee. It is the employee. Is the
Yeah, I'm employed. I'm employed.
next step. The brief facts of the case is that the employee bracket workman was orally employed to maintain the accounts of the employer with effect from 14/11/19. The employer used to pay rupees 1,000 per month as wages for the period from November 1996 to December 1999. Thereafter, her wages was increased, and till the time of her dismissal for till the time of her dismissal, her wages had increased to 4,000 per month. The employee was dismissed from service on when was it? Was
2010.
huh? 20,
2005.
22/05,
10.
2010.
My lord, kindly one thing mention, my lord. My appointment date, matter. I was engaged on 14/11/1990.
I have already said that.
Ah,
If you have heard, I have already said.
my lord. Okay. Tell you.
Next time. The employee being aggrieved submitted a complaint with regard to her dismissal from service, and as the conciliation attempt failed, however, the issue was referred to the labor court for resolution of the dispute in terms of the Industrial Disputes Act 1947.
Then of this record on the second pen of
Referred under section 10 of the Industrial Disputes Act 1947. The case of the wherein the case of the employee was registered as what is the case number?
reference case number 2 of 2012, page 35. The case number 669.
It is there, there. Reference case number 2 of 2012. Next one. the employee, no, during the proceedings of reference case number 2 of 2000, the following issues were framed by the labor force. Number one, whether the employer was justified in dismissing or discharging the employee. And number two, if not, whether the employee was entitled to be reinstated with full back wages and benefits or any other relief whatsoever as may be deemed fit as law. Next up. The case of the employee before the labor court was that a dismissal was illegal, a dismissal from service was illegal, and that he should be reinstated with full back wages and benefits. The employee also made a prayer that as the employee bracket workman had joined her service as a grade 1 employee, the employee should be given her full back wages as per the salary, as per the pay given to a grade 1 employee. Correct? Next slide. The learned labor court, while its award dated 30/3/2030 held that the employer was not justified in discharging the employee from a service and that he was to be reinstated in her service with full back pay. With regard to the prayer of the employee that she should be given her pay as a grade 1 employee, the learned labor court, Guwahati, in para 18 of the award held that the claim of the employee that she had been given an amount had been given a lesser amount than what she was entitled to was a matter to be considered by a separate forum under a separate section of law. And hence, the claim of the employee for grant of back wages as per a grade 1 employee was rejected. Next paragraph. Being agreed with the decision of the labor court Guwahati in while its award dated 30/3/2030 to the effect that the employee should approach a separate forum under a separate section of law for grant of back wages as eligible as entitled to a grade 1 employee. The employee approached this court by way of WPC 6968/2030. the prayer of the employee before this court was that the award dated 30/03/2013 passed by the Labor Court, Learned Labor Court, in reference case number 2 of 2013 should be modified in accordance with the provisions of section 70 capital A of the Industrial Disputes Act 1947 by directing the employer to reinstate the petitioner with full back wages as per no, as per which should be where is the prayer made that be given as per grade 1 employees in the before this court?
What this court, the earlier application,
Yes, yes,
that was in the judgment
yes, sir.
by the Supreme Court. I think the judgment starts from page 50. Yes, it not say. Dot one. At page 52.
Where?
Page 2, your lordship, the workman, 1, 2, 3, 4, 5, 6 line. According to the petitioner,
Ah,
she was right.
where do I say? Where do I say? No, full back wages. Uh, uh, I'm giving her higher pay scale as per her entitlement. Next one. WPC number 6968 of 2030 was dismissed by this court by order dated 21/7/2015 by holding that if the petitioner had any further grievance as noticed in the award dated 30/03/2030, it would be open to the it would be open to the employee, not petitioner, employee, to raise such grievance before the appropriate forum in accordance with law. Pushpa. Next part. Next para. It may be pertinent to, no, the prior to the dismissal of WPC 6968 of 2030 by this. Committee. The employer had written letters dated 19/8/2030 and 25/8/2040 to the employee asking her to join her post of a receiving and delivery clerk within 15 days. So don't say 15 days. Delivery clerk in pursuant to the award passed by the labor court. But or else the said post will be filled up by a new incumbent poster. Next up. Subsequent to the order dated 21/7/2015 passed in WPC 696/2007. The employee submitted a claim petition before the Assistant Labor Commissioner, Ulubari. For giving her wages as per grade 1 employee, correct? And the said claim petition was registered as LPW number 16/2015. The said case, the said LPW number 16/2015 is still pending till date before the labor court. Yes, before the labor court. Guwahati. Next para.
Assistant Labor Commissioner.
Before the Assistant Labor Commissioner,
What?
what?
He is actually, he is the authority under the payment of wages. He's
Okay.
under the authority of the, could be Labor Commissioner, but the authority under. payment
Okay, Assistant Labor Commissioner, Guwahati, who is also the authority to decide issues relating to the Payment of Wages Act.
Of my.
Payment of Wages Act 1936. So which authority should he go to actually? There's no authority actually.
What would have, is the correct procedure, which we have stated of, that he should have, first and foremost, the award. He has actually, in fact, it is an award or an order of the court, which they are not fulfilling, number one. They should have, he should have, or she should have immediately went and joined.
Joint, it's not joint. that is
You
joint.
take the, whatever your back wages, you take, then you raise a dispute. There is always a dispute. You have to raise. Similarly, a dispute is raised with the management. It's always management and board.
Correct, correct.
Yeah. So raise the management. The management, if it accepts, then it's over. If it doesn't accept, then they have made an application before the authority, the Assistant Labor Commissioner. Then the Assistant Labor Commissioner will go for conciliation proceeding. If the conciliation fails, then it is
Refer
referred.
it.
Then it is referred for a decision.
So,
on-
so now it's not now that has all been bypassed.
He just made an application before the payment of wages authority, whereas the payment of wages authority does not have even the authority to grant.
Decide.
That is where he or she.
It's not the fact, my lord.
I'm saying from what is
Very
there.
humbly for it, but so I ask your lordship to request the law, call for the court. Record else.
No.
So that
That
will
I'm not-
come out, my lord.
No. You see,
What
those,
happened
those,
here?
those are not arguments. You have to give me concise argument. Not on my, I'm not going to delay the matter. If you in that event, you have got the DB. You can understand.
He is poor and poor employee.
No, you see, I'm not on that.
I-
Poor, not poor. If he's deserving, we'll give. If you see, I have to go by the law. I cannot go beyond them. I have got to pass my order as per the law.
Your relief kindly given what I have thought.
The order was passed in 2013. For 11 years, you have most probably told your client not to join. What kind of advice you have given?
And she intended to join, but her demand was not.
11 years have passed. Do it. Now this writ petition has come in the meantime. I have got to decide the writ petition, not as I want it, but as the law requires it to be. My hands are tied. I've got all the sympathy for you, but then I've got to dispose it of as the law requires. It has been filed by him. Before filing, you could have always joined. You had 11 years to join. 11 years. It's not 1-2 months. You had 11 years to join. You did not join.
Right. Kindly consider my case regarding my back wages, but what my working period has not, if my working period has not been paid, that may kindly.
Right. Subsequent to the above event, the employer issued a letter dated 18/8/2023 to the employee stating that in reference to the letter dated 25/8/2014, in connection with the award dated 30/03/2013 passed in reference case number 2 of 2012, whereby the petitioner was to be reinstated in service with full back wages. The employee had been asked to rejoin her post, which has, however, not been done by the employee, despite a lapse of several weeks. The employer thus stated in the letter dated 18, in the notice slash letter dated 18/8/2020, that the award dated 30/03/2013 passed by the Labor Court in reference case number 2 of 2012 had spent its course. Next step. In reply to the employer's letter dated 18/8/2020, the employee wrote a letter dated 29/8/2023 to the employer, stating that she had received the letter dated 19/8/2020, though not though not the letter dated 25/8/2014. The employee further stated that the employer was wanting to deprive the employee from getting her legitimate pay, and that as and when the employee was provided the legitimate pay scale of a senior grade 1 employee, comma, the employee would be ready to comply with the award passed in reference case number 2 of 2000. The next para. The contents of the letter dated 29/8/2023 submitted by the employee to the employee is reproduced herein below as follows. Page 69. I'll put this up. Yellow. Next up. The petitioner's counsel submit that the facts of the case show that while the employer slash writ petitioner had accepted the award passed by the learned labor court in reference case number 2 of 2012 and was ready to reinstate the employee with full back wages, that is at the rate of rupees 4,000 per month, which is the fixed pay she was receiving at the time of this dismissal from service. The employee failed to rejoin her post. He submits that the employees they submit that the employee did not rejoin her post only on the ground that she had not been given her back wages as per her entitlement, which was in the pay scale of senior grade 1 employee. However, the said prayer of the employee had not only been rejected by the learned labor court, but also by this court in WPC number 6968/2013, wherein liberty had been given to the employee to approach the appropriate forum in accordance with this. He submits that the employee could not have approached the assistant labor commissioner with regard to her claim for the pay scale of senior grade 1 employees. under the Payment of Wages Act 1936. Under section,
In section 15, they have approached.
under section
15, they have approached for
15 bracket 13. 15 bracket 3.
they have approached number 15. And
15,
for
15,
enforcement
sir.
of section 3, 1B and 5.
15, 3 they want.
They have written it.
Under section 15.
Yes, 15.
15 of the Payment of Wages Act for enforcement of section 3 bracket Roman 1 small b small b and 5 bracket 1 small and bracket b small of the Payment of Wages Act 1930. What is the submission here that this Custom Labor Commission has got the authority?
No, there was a delay. They filed an application, but on it not, he condoned the thing.
Correct.
Then we came before the Honorable Court saying that he does not even have an authority to adjudicate this case. Number one, at the adjudication. Secondly, your lordship, these are the people. He doesn't have the authority. And secondly, it's a registry. So they again, he's going to say.
What is going to?
No, initially he filed an application before the same authority. And then he wrote the application saying that he will file an application under the industrial dispute. Act.
Acha, he went earlier. Yes, where is that?
So that I initially wrote.
Yes. Page 22. He submits that the Assistant Labor Commission does not have the authority to decide the issue raised by the employee regarding her entitlement to the pay scale of a senior grade employee. In view of the fact that
Just a second. What I'm trying to point out, I just forgot. He is for senior grade 1.
Yes.
First, there has to be an application that she's working as senior grade.
Correct.
That adjudication is not there. That is where we have said that he doesn't have an authority to decide how he will be getting. That is
in view of the fact that there is nothing to show in the record that the petitioner has been appointed or worked as a senior grade 1 employee. Further, the employee had earlier approached the Labor Commissioner.
it's still labor.
No. Office of the Assistant Labor Commissioner on 29/10/2010. 5 application number.
That is
not there.
no, it is given subsequently LPW 5/2000.
The white LPW number 5 of 5/2010, which was disposed of.
Here, my lord, application number LPW 510 to CPS Khaobum Labor Inspector Appellate.
Which was disposed of.
Another number order dated at page
By-
30.
Page 33, which was disposed of by order dated 8/6/2011.
Yes.
Wherein the Office of the Assistant Labor Commissioner has held that but where is the order?
This is the type copy 8/6/2011. In the page 34, the order is a handwritten order here. So I have typed it. Page 34, handwritten.
Was disposed of, what have I said? has held up. But there's nothing given here. Please read it.
No, it has given that, no, what has been claimed, filed, petition had prayer for the, no, claimant filed a petition with a prayer to entertain the matter under the Industrial Dispute Act 1948. So he then made an application that I will file an application under, in the Industrial Dispute Act. So he said that since this is already a dismissal matter, the matter should go before the industry.
Where does it say that?
That is at page 33.
Has held up. As the But you were dismissed when? You dismissed when?
Was dismissed on 2000. sorry, On 25, 2010. After the dismissal.
And held up as there was already a dismissal case involving the petitioner, correct? Involving the employee before the no, under the Industrial Disputes Act 1947. 1940. No, this is Industrial Disputes Act.
1947.
If it's 47 is written 48.
In the top it is written 48, but later on it is
That's
correct.
1947.
He himself wrote it wrong.
Regarding the dismissal of the petitioner from dismissal of the employee from service. The employee may move the appropriate forum under the Industrial Disputes Act 1947
That is
for the claim made by the petitioner for grant of the pay scale. But where is it in this page 22? That he's claiming grade 1 employee.
here it has not been stated as grade 1.
No.
Nothing has
For
been-
claim of higher,
specifically
for
nothing-
claim of higher wages.
higher wage. Just
Higher wage.
stated higher wage.
So that was decided by the labor court then. Now, once the labor court has decided as such, the assistant labor commissioner, which is a lower authority.
Lower authority.
Cannot be. So he accordingly submits that as the claim of the petitioner has not been touched, the claim of the petitioner for pay of higher, for grant of higher pay scale has not been exceeded to by the learned labor court and this court. The petitioner cannot go to an authority lower than the learned labor court for grant of a higher pay. He also submits this para. The counsel for the petitioner also submits that in terms of section 19 bracket 3 and section 19 bracket 6 of the Industrial Disputes Act 1947, the employee not having rejoined her post in terms of the award dated 30/03/2030 Past tense. Reference case number. Past tense reference case number. 2 of 2012. Even after a lapse of 2 months from the date of receiving the date of receiving the letter slash notice dated 18/8/2023 issued by the employer, the award cannot bind the parties any longer, and the same must be set to have spent its course. Next up. That's all I think. Any other things? Next up. And Mr. HR Khan, Planet Council for the employee. On the other hand, submits that the employee has submitted an application for grant of higher pay scale than what has been provided in the award number 30 of 33/2013. Past is a reference case number 2 of 2012 before the Assistant Labor Commission, along with a condonation of delay application. The condonation of delay application has been allowed by the Office of the Assistant Labor Commissioner, and the issue raised by the petition by the employee is to be considered in LPW number 16 of 2000. 16 of 2015. 16 of 2015. He submits that until a decision is taken by the Assistant Labor Commissioner in LPW number 16 of 2015, the present writ petition should not be disposed of. He further submits that as the records of LPW number 16 of 2015 are not before this court. It should not come before your. Not before this court, comma. This petition should not be disposed of. Further, all the issues raised in this petition should be referred to the Office of the Assistant Labor Commissioner. For adjudication. That's all. Anything else?
That's not right. This is my one paragraph only my subject.
That's all, no? I have heard similar talk for them. As can be seen from the facts enumerated in the foregoing paragraph. The petitioner that the employee has been terminated from service on
My lord, 2010.
5/2025, 2010. The conciliation regarding the grievance of the employee having paid the matter was referred to the late learned labor court, wherein reference case number 2 of 2012 was registered. The learned labor court in the award dated 30/3/2013, disposing of reference case number 2 of 2012, has held that the employee was designated as a clerk and he was directed to perform as in charge in the warehouse as a clerk. So he was directed to perform as a clerk. Further, he was paid wages at the rate of rupees 4,000 per month at the time of removal of a service as a workman. The learned labor court has directed the reinstatement of the employee with full back wages. And as stated earlier, her claim for payment of higher wages as entitled to a senior grade 1 employee was not exceeded by the learned faculty. Don't say senior grade 1, say grade 1 employee. Grade 1 employee was not exceeded by the learned labor. The challenge made to the award passed in reference case number 2 of 2012 in WPC 698 of 2013 was rejected. The employee did not rejoin her post even after a lapse of 2 months from the date of receiving the letter/notice dated 18/8/2023. There's nowhere which says that this is under section 19.
We did not state that they actually have put the notice that that the award to be a terminating case. There is nothing to state that it is under 19. Because the Honorable Supreme Court says that at least the other parties would be intimated. That's why I've given a judgment. But it has the intimation as
But what
they are, your lordship, just management. They have issued a letter that if you don't join, they are terminating. That's. But that issue has not been raised in any way. That's for 90 regarding. Now my question.
So section 19 is not there.
But section
Now it
19,
is on-
is it required in order to put that it is under 19?
Why
It's
not?
stated that
Why not?
because
Otherwise, even that earlier letter of 2013 and 14, that can also be, you can also say that
there is a catch here. The earlier letter, after that, the judgment of the Honorable High Court came. That is why. Because if the High Court reversed the judgment, then those letters would have become defunct. So therefore, your lordship, and they took a very long time in that, much longer. That actually they could have done it long time. If
Next,
she
you're
would
right.
have come after
Next, you're right.
within that 2 months, your lordship, they would have
The
paid.
letter, the contents of the letter dated 18/8/2020, issued by the petitioner, issued by the employer to the employee, is reproduced here in the page 68, huh? In that 66898. But after yes, it appears you are no longer eligible to enforce the award. It says it.
That word is
That
there.
word is no longer.
Word is
eligible.
there, but actually.
Then you write, next right, section 19(3) and 19(6) of the Industrial Disputes Act 1947 states as well. Or should we put the entire 19? Because I think for you just copy paste. Huh? You just give section 19. States as well. Just give. Next. The letter fax notice dated 18/8/2023 as categorical refers to the fact that despite 2 letters being sent to the employee, the employee has failed to rejoin her post as per the award dated 30/03/2013 passed in reference case number 2012, and that the employee was no longer eligible to enforce the award as the same had spent its term. This, in the opinion of this court, amounts a notice being given under section 19(6) of the Industrial Disputes Act 1947. Next one. In the case of Bank of India versus presiding officer and others, reported in 2001 8 scale 104. The Supreme Court has reiterated the view, reiterated the decision of the Supreme Court in the case of South Indian Bank Limited versus ARCHAO. AIR 1964 AIR 1522.
Then in the next page, this until the parties intimate to each other about the intent.
Where?
See, para 5,
Ah.
referring to Chaco,
Ah.
court says, the court took the view that under provision 19 in the an award shall continue to be binding on parties even after period under 19 be expired. Section 4 of the industrial company's decision will not affect the same. It is observed that if an award does not
Just a minute,
enforce
just a minute.
or it has ceased to be binding on the party in view of the provision of 6 until the parties intimate to each other about the intent to. So this, in fact, has not quoted clearly. This was quoted in the South Bank. Versus AR Truck. South Bank AR Truck page 5.
Wherein it has been held that when the period of operation of an award has expired under section 19
3.
3 of the Industrial Disputes Act 1947, the award does not cease to be effective. No, no, no. 96.
1906 is the notice.
Until, until. A period of 2 months is elapsed from the date on which notice is given by any party bound by the award to the other party, intimating its intention to terminate the award. The Supreme Court in South Indian Bank Limited versus AR Chaco CHACO Supra has held as follows. It is including from here to here. In the case of Karnani KARNANI Properties Limited, World State of West Bengal and others, reported in 1990 SCC 4472. The Supreme Court has held
Here, the lordship just intimation is.
Hmm?
This case, it states that only intimation is given. That paragraph the lordship is not there. In our opinion, this contention does not refer to binding.
where is that?
Page 8.
Which portion? In our opinion,
Yes, in our opinion, this contention does not refer consideration. I'm not reading everything. In our view, of finding recorded by the learned division bench of the High Court that the letter dated so and so was a notice after section so and so as well as section 92 of the Act.
Has held that a letter
Yes.
given by way of an intimation stating the intention of the employer to terminate the award would amount to fulfilling the requirements required under section 19 bracket six, as well as under section 19 bracket 2 of the Industrial
it is
Dispute
three.
Act
In our
1947.
case, three. Not-
Huh?
In our case, it is three.
Ours is
19.6 and 19.3.
6 is our mistake.
19.6 is the 2 months period and 19.3 is the period
1
of
year.
1 year.
One year. Okay. In the present case, the award was passed in the year 2030. And the letter stating that the award became unenforceable was intimated by letter dated 18/8/2023. And as stated earlier, it is the view of this court that the award became unenforceable after the lapse of 2 months after receipt of the letter/notice dated 18/8/2023 by the petition by the employee. The fact that the employee had received the letter dated 18/8/2023 is proved by a reply dated 29/8/2023. And the fact that he had not joined the post even till today in terms of the award dated 33/13 passed in reference case number 2 of 2000. Next slide. In respect of the question whether the petition, the employee is entitled to the payment of a higher pay scale than rupees 4,000 per month. Comma. There is nothing, comma, there is nothing to show that the petitioner, that the employee is entitled to a higher pay scale. This is in view of the fact that the learned labor court has clearly come to a finding that the employee was receiving rupees 4,000 per month at the time of dismissal from her service. And the same has also not been disturbed by this court in WPC number 6968 of 2007. Further, as the learned labor court had decided, had come to a finding that it was not the appropriate authority to decide the issue as to whether the employee was entitled to a higher pay scale. The said question cannot be decided by the Office of the Assistant Labor Commission. Got it, correct?
Without there being adjudication.
Without there being any adjudication by the employee in terms of the Industrial Dispute Act 1940. That's all. In view of the reasons stated above, but does not find. In view of the reasons stated above, what finds that the uh, employer / employee has made out a case for for interfering with the case pending before the before the office of the Assistant Labor Commissioner. That is LPW number 16 of 2015. Besides making out a case that the award number 33 2013 passed in reference case number 2 of 2012 has become unenforceable in terms of section 19 and 19(6) of the Industrial Dispute Act 1940. The writ petition is accordingly allowed. The writ petition, accordingly this court holds that the award dated 33 2013 passed in reference case number 2 of 2012 has become unenforceable as it has spent its force. Besides, no, first of all, also the proceedings before the learned Assistant Labor Commissioner in LPW number 16 of 2015 is not maintainable. And accordingly, what accordingly is not maintainable. That's all. Anything else should be added?
This case may proceed, we may propose there. But it is pending there.
How can we do it? How can? That will, huh? That is it. The writ petitions are accordingly disclosed. Huh? Common order.
My lord, I have given two judgments, my lord, I am getting it back because it is not something legally done. So now, no, I have given your lordship for you. So I am doing it. It is something different.
He's drawing the judgments provided.
Oh,
Your lordship, because it is with regard to something. Your lordship, in that case, I think they are not set aside what may be used. Otherwise, maybe set aside. How this can be.
which one?
LPW.
After it's not maintainable.
The record not before your lordship, how it can be done?
No, you see, it's not that. It's like this. If a high court says, if a high court says that this court, if the labor court cannot decide an issue, can a authority below the labor court decide the issue?
Ultimately, the matter is subrogates. That is not one. Your lordship, any confidence.
You have to mention about the Payment of Wages Act 3 and 5.
No, you're not mentioned. At the initials. Required your lordship may B1, B51. Is it not? Yeah.
C1B. Put up. And you write. No, one thing. Let's put somewhere, I'll put it later. Just by the end. Huh? Section 3(1)(b) and Section 5(1)(b) of the Payment of Wages Act 1936 states as follows. A perusal of the above provision clearly show that the same does not relate does not relate to determination of whether a person is entitled to a higher wages or not. The same only reflects the responsibility of an employer for payment of wages and the time for payment of it, and nothing beyond the above. As such, it is not understood as to how the petitioners, the Court of the Labor Commission would be able to decide the issue raised by the employee. Besides the other point raised, besides, in view of the other issues already decided by the, with respect to the claim of the employer for payment of higher wage. Huh? Have I missed out something? I think that is all.
Your lordship, might even come.